Good morning, Ms. Davis.
Good morning, Chief Justice, members of the Commission.
How are you?
I'm well. I had a good night's rest, and I like to think that the commissioners did too. I know you had a very long day yesterday, and I felt for you.
No, that's very kind of you. Thank you. And I'm happy to, to hear that at least one of us here had a good night's rest, because I suspect I speak for many of my colleagues when I say we don't get much sleep during JS week.
I can imagine.
Are you ready?
I'm as ready as I'll ever be, CJ.
Good. All right. I was quite pleased to see that you were born in my hometown.
You mean Mthatha?
Mthatha,
Yes, and I spent the first 10 years of my life in Ngcobo.
Oh my goodness. So you and I were babies around the same time, not very far from one another, maybe in the same town.
You know, it struck me when I read your CV, it struck me that that is exactly so.
Yeah.
So near and yet so far.
Yeah, indeed. You have two degrees, a BA and LLB, obtained magna cum laude from the University of Cape Town. Do you confirm? Is that
That's
you?
correct. The BA was not cum laude, but the LLB
No, the
was.
LLB though.
The LLB was, yes.
Yeah. You've done well. You've always been not quite. You started out, was that an internship at is it Regensburg University in Bavaria?
Yes, that was a
You
filler.
already had your
Yes,
law degree at the time.
I did. And my intention was to go further to study overseas, and that was sort of a filler. Some people take a gap year. I went and spent 6 months editing a book in Regensburg University, but it was a wonderful opportunity, and I got to travel a lot, and it broadened my horizons. Then I spent 6 months studying at the University of Toronto. And then I decided that doing a master's at that stage of my life was not for me, because I decided I didn't know enough about the world, and that writing a master's when I really didn't have any life experience was going to be a waste of time. And so I didn't complete the master's, and I came back and I knuckled down and I went and did articles. Some would say I came home with my tail between my legs. I don't see it that way. I made a choice, and I think it was a wise choice. I don't believe in empty scholarship. And I knuckled down and went to the sidebar. I went and did my articles for 2 years. I qualified in 1991 at Melanex Attorneys. I practiced there for about 2.5 years. And then I felt the pull of the bar. And
in 1994.
In 1994, beginning of 1994. And in fact, it was a woman advocate at the bar who had encouraged me. She'd seen my drafting one day, and she said to me, you know, you're good at this, you should come to the bar. I probably wouldn't have thought about it. And as I sit here, I can say, if I knew then what I know now, I don't know if I'd have had the courage to do it. I was at that stage naive, and I believed that talent and hard work was all you needed. Boy, did reality bite hard.
Yeah.
But here I am, and in July this year, I will be 32 years at the bar.
Wow. And you took silk in 2018.
2018, that's correct. The recommendation was made in 2016, but it took a while for the letters of patent to be signed, but 2018 was the official date, yes.
Why did it take so long? You were acting in the High Court.
No. It took a while for the president to sign the letters of patent.
I see.
No, that was the holdup. No, I started acting. Well, I've had, CJ, as you know, I've had a number of acting stints. My first acting stint was in 2012 to 2013, where I met Justice Mabindla Bokwana. We were colleagues at the time. And then I had another stint from 2017 to the end of 2019. And then I had a term at the end of last year. If you tally that all up, It's 3.5 years of judicial experience.
Okay. What kind of work have you been doing in this 32 years? What kind of practice do you run?
In the High Court.
No, your practice.
In my practice. I had an eclectic practice. People often talk about choosing their field of practice. I think sometimes things choose you, and pretty much at the bar you take what you get. I've had an eclectic practice. It's been a mix of pretty much everything. No, not criminal. I've done criminal at the bench, but I didn't do criminal at the sidebar, at the bar. Commercial, insolvency, some administrative law, gender reviews, lately a lot of arbitration. I don't tend to litigate family law because I don't believe in that. I'm a strong believer in mediation. I do a tremendous amount of mediation. For a while, I did what is known as parenting coordination. I don't do that anymore. It's something that's not compatible with the rest of my practice, but I did do it for a while. Yeah, and lately, increasingly, arbitration and mediation. I like to litigate less. So, in a word, eclectic.
Yeah, I do see that you have deep ties to the ADR world. You have membership in a number of associations, the Arbitration Foundation, Chartered Institute of Arbitrators in the UK, the ADR Group in the UK, the Africa Center for Dispute Settlement, and others.
Yes, over the years, I've always had a desire to learn, to grow, to add to my skills. So I've done various courses and various qualifications along the way. The most significant for me personally was all the mediation training I've done. I started with that way back in 2008, and I've done it along the way, both commercial and family mediation. That has been life-changing for me. And you might be thinking, well, if you're so into mediation, why do you want to be a judge? Well, I believe that the two have a lot to complement one another and a lot to offer one another on. I believe strongly that mediation is one of the great tools in our toolkit of access to justice. I believe that the bench has a role to play in supporting mediation, not foisting it on people, but supporting mediation. And I'm excited at the notion of possibly exploring what I like to call judicial mediation. I'll give you an example. During the last term, one of my judicial colleagues had a very difficult, complicated family law matter, and she expressed the view that she wished that it could be mediated. And JP encouraged that I attempt to mediate it as a judge in open court. And so we created a Chinese wall, if you like. We invited the parties to participate in judicial mediation if they were willing. We made it clear that the judge who was seized with the case would have nothing to do with it, would have no discussion with me, no involvement in the mediation, and that if the mediation didn't work, the case would go ahead. But of course, if it did work, there was the chance that I would be able to get the parties together to settle and save all the hours that the judge seized to the matter would have to spend hearing the argument and deciding the matter. Now, it didn't work that time, but I think that that's because the matter was so far along that I don't think it could. The parties were too investigated in the litigation process. I think if it had gotten to them earlier, it might have succeeded. But what was so encouraging to me was the absolute enthusiasm with which the legal practitioners participated. The parties themselves participated. It was held in open court. It was on the record. I sat in my robes on the bench. They participated. So it was very different from the kind of mediation I do in my chambers where they're around the table and we're talking. This was very judicial, but I found it incredibly powerful. The parties listened. I was able to guide them. I was able to say, if I were deciding this case, I'm not, but if I were deciding this case, I would think this, I would think that, Think about it. And if you're going to fight about this, you're going to spend days in court and it's going to cost you a fortune. Don't you want to think about this? Why not explore this solution? It was very powerful, and I'm excited, and I believe there's a future in it, and I see a role for it in helping to alleviate what I see as a growing burden of high conflict family law cases in the High Court. But let me not get started on that. I think I've said enough.
I'm quite encouraged to hear you speak so passionately about this. And I was actually going to say that if you are appointed, you'll be in very good company, because JP Mabintla Pokwana is one of the key advocates for court annex mediation in the judiciary. So.
Well, I speak with great passion because it is absolutely from the heart. It's something I believe in. I believe in collaboration. I believe in problem solving. And so that's where I'm coming from. And I believe in saving people money. I can't tell you what breaks my heart more than when I see people come to a divorce, and by the time they get to court to litigate the issues, they have bankrupted themselves. And I think what you could have done with that money for your children. And so I want to be part of spearheading, stopping that from happening.
Indeed. That is exactly the kind of thinking that us all judges should be entertaining now. Enough of that. You have published, you list an article, the legal position of the embryo in vitro in South African law.
I think that's probably
that
like
was
dinosaur
earlier
T-Rex now. I mean, that was done in 1987.
Yeah.
The law has moved on.
But at least that's something you can, add to your list of accomplishments that shows that you had a taste for writing even back then. And you mentioned, or you would have done this during your working holiday in Germany, the editing the Professor Zimmerman's book.
Yes, it was such an enriching experience, a fascinating experience. Professor Zimmerman took, I think, roughly 10 years to write that book. And what was fascinating to me was that the beginning chapters were full of red pen, heavily Germanic style, having to be made more accessible. But 10 years later and 300 chapters later, his style had improved, and so the red pen was less. So that was part of the role, was just editing, which I have a passion for. And the other part, which some people curl up their toes in horror at, was that I had to check all the Latin footnotes. But I found it absolutely fascinating. I was taken into the bowels of the university, into an archive, and I was given original manuscripts of the Corpus Juris Civilis to work with gloves and in a climate-controlled environment. You can imagine, for a young person in her early 20s, this was mind-blowing. I'll never forget that, and I'm grateful for the opportunity.
Yeah, wonderful opportunity. It must have been indeed. The eminent silks among those who have nominated you say you have contributed immensely to the law outside your practice, and they list your participation in training programs for candidate attorneys and pupil advocates involving Black and female juniors in your cases, doing pro bono work, and your involvement in the Cape Bar and many of its structures, and in the LPC. These are all things you have done.
Yes.
All right. You did the training course for aspirant judges in 2012 already.
Yes, I did.
Run by Sajay.
Yes.
Did you find that useful?
Absolutely, absolutely mind-blowing, absolutely inspiring. I still remember it today, and I still remember Justice Norbo, as he then was, teaching us about judgment writing in Filaro. Introduction, facts, law, issues, and so on, in Filaro. I still use it today.
That's I'm sure one of the commissioners somewhere over there will have something to say about that. That's one of the third questions for candidates. Okay, let's come to your acting stint as a judge. So you started acting in 2012.
Yes.
And when was your last stint?
My last, so I did a year then, 2012
4
to
terms.
2013. I did a stint from October 2017 to December 2019.
19.
Then I did a term, the final term of 2025. But I must add that in between, I did a major amount of ad hoc work finalizing the Murphy organized crime trial. So many, many hours. And in fact, I took a whole month off to write the judgment in that case. So I've, kept my hand in along the way.
All right, but that's a long time on the bench. So I would imagine that you have sat in all the courts in that division.
Yes, I've been absolutely so privileged and benefited to have an opportunity to have a wide range of exposure to pretty much everything that happens in that court. I think the only thing I've only done one of is a maritime case. But I've done pretty much everything else. And I was so grateful in the last term of last year to sit on 3 full bench appeals, and I got to write the judgment in 2 of those full bench appeals. And I'm very grateful for that.
I'd like to think that many maritime cases, come to the court. Why do you think you have not sat in such case?
It was, I only got one maritime matter because I don't think there are that many. I don't think there's any specific reason why I haven't done any more maritime. It's just I don't think that there's that much of it at the Cape.
All right. So there's no senior judge. There's no judge president who's hogging maritime cases to themselves.
No, I don't think so. I doubt it. And let me say, I'm not afraid of a maritime case. I'm not afraid of anything that I haven't done before, because I believe that as lawyers, we are always learning. And one must never be daunted by something one hasn't done before. One knuckles down and one reads up and one studies and one works a bit harder.
Yeah, that is indeed the approach. The approach to to a case is the same, be they criminal, be they civil. So even if you've not done a case before, the application of the law, the way you do that is just the same, and you learn on the job, as you say.
Absolutely, and never be too proud to go and knock on a door of a senior colleague and get some pointers.
Yeah. All right, you've written judgments. How many judgments have you written?
How many judgments have I written? I don't know how many judgments I've written. I have listed 13 reported judgments. It's up to 14 now. Another one was reported in January. And I've listed something like 37 reported in digital platforms, not including Safely. So I've worked really hard at my judgments. I've put my everything into them, and I am passionate about them.
One thing that did concern me about your impressive CV and wealth of experience is your lack of experience in criminal law, which is a very important aspect of judicial work. Have you done
in criminal
work?
Yes.
Have you done enough of that during your acting stints?
I believe I have. I was fortunate to, besides the Murphy trial, I did a number of criminal trials. But the Murphy trial was a marathon which covered A to Z. It had every possible ingredient in it that you can imagine. It had 6 trials within a trial, dealing with different issues, search and seizure, and various admissibility of evidence issues. There was an application to set aside subpoenas. The defense subpoenaed the prosecution. The prosecution applied to set aside the subpoena. The state didn't want me to hear the matter. I said, I'm the presiding judge, I should hear the matter. They refused. It went off to civil court to Judge Salzana. He bounced it back to me a year later. In short, I can assure the Commission that having dealt with the Murphy trial and then all that followed afterwards, I feel confident that I can hold my own in criminal matters.
Right. And you did not struggle dealing with that case?
No, I didn't struggle. I worked very hard, but I didn't struggle.
Okay. All right. I'm going to hand over to Judge President Mabindla Kokwana to put questions to you.
Thank you, Chief Justice. Good morning, Ms. Davis.
Good morning, Judge President.
You and I, you're quite right. We acted together many moons ago, and that's when I got to know you. So you've acted in that division when I counted for 112 weeks, including last year. And you've written on complex matters, and you've seen generations of judges coming and going in our court. And can you tell me, when you came back last year, how did you find your acting stint? How was the environment in the division?
I was not expecting to enjoy it as much as I did. You know, JP, you will recall that when I congratulated you when you took office last year, I made you a pledge. I said, if you ever need anything, you only have to ask. So when you called and invited me to act, I made good on my promise. I stepped up, but I didn't think to the future. I didn't think that I would be applying again. I honestly, it wasn't on my mind. I wasn't prepared to what extent I would enjoy it and to what extent I would just fly through the term. I found the atmosphere in the court wonderful. I found a congeniality, a collegiality that really impressed me. And I was so grateful to be involved in those full bench appeals. And really, I just put my all into it, and I loved it, and I flew.
Yeah, I received good feedback. Now you talk about full court that you sat in last year. I think one of them was the Section 18.3 matter that you did. And I got good feedback from one of the senior colleagues that you were able to produce a judgment quickly on the issues there, and they were so well reasoned. Yes? You want to say anything about it?
Yes, it was less than a week. It was 6 days. I burnt the midnight oil, but the Superior Courts Act says that those matters have to be dealt with. It's a matter of extreme urgency, and I took that seriously, and I dealt with it as a matter of extreme urgency. And I'm glad to say that the other full bench matter, which was a review, I was able to get the judgment out with my colleagues, having circulated to them and having their input. We delivered that judgment in 2 weeks.
Yes. And maybe just to tie it back to the first question I asked, our court is losing a lot of experience at the moment, as you know. And one of the things that the courts need are colleagues that are team players, that are collegial, and that would foster the vision of the court. And secondly, have obviously the technical skill and ability and the temperament required and other qualities that are required. What is it that you have that you think, were you to be appointed, you would bring to the division?
JP, I couldn't agree with you more on the value of collegiality and being a team player. I see the members of the bench in your division as part of your team. Nobody's an island, nobody's there to advance themselves or to show off. You're there to work as a team to deliver justice. And so for me, collegiality and respecting the work of others and encouraging them and uplifting them and having a kind word, I think there's such a need for encouragement of one another in a division where the workload is absolutely backbreaking. And that brings me to the second point of experience. Why is experience so important at this critical juncture of our division's history? It is this. As you correctly point out, JP, we have lost decades worth of experience if you add it up in terms of senior judges retiring. So we've lost a huge wealth of intellectual capital. And coupled with that, the workload in the division has grown exponentially. I can see the difference between my last term last year and when I was there a couple of years ago. And certainly, looking back to 2012, I can see an absolute explosion of work. And the colleagues are suffering. I care deeply about the judges on the bench in the division. They're suffering. The workload is backbreaking. And we know that we've got to get judgments out on time. But sometimes it just isn't humanly possible. And so what I'm offering you is about 35 years of experience in the legal profession and a track record of judgment writing and dedication and a willingness to be a team player. I mean, that is me. That is my personality. I'm a problem solver, I'm a fixer, I'm a mediator, I'm a bring everybody together kind of person, and I'm an encourager. If I were to say one thing about myself, I always see the things on the bright side, and I've always got a kind word for people. And people know that my door is open, that they can come to me if they're in difficulty of any nature. So that's what I would offer.
I just want to explore two more questions with you. First one, you were asked about your experience in criminal matters. You've done a number of criminal trials, and you've talked about trial within a trial. And are you familiar with the confessions and admissions and how you deal with that when it arises in a criminal trial?
I'm not sure if I understand the question. JP, yes. Perhaps you could just repeat for me.
You've spoken about trials within a trial, in a criminal trial, right? And from time to time, there will be a challenge where the accused are challenging a confession or an admission that is said, that the state would say they have made. How do you deal with that in a trial?
Right, I have you. So you will have a trial within a trial. Whenever there is a challenge to admissibility of evidence on whatever basis, whether it's to challenge the legality of a search and seizure or to challenge the voluntariness of a confession, and so on and so forth. So whenever admissibility of evidence is challenged, you have what's called a trial within a trial, which is a sealed off proceeding where you decide only on the issue of the admissibility of the evidence. And that is sealed off from the rest of the trial. So if you rule at the end of the day that evidence is inadmissible, is excluded, it's not part of the record, and then when you come to judge the case at the end of the matter, you disabuse your mind of it. You've got to pretend that you've never ever heard it. No matter what was said in that criminal trial within a trial, you blot it out of your mind. If it's inadmissible, it's inadmissible. It doesn't get into the decision. If you rule it is admissible, it's included, then very often the record in the trial within a trial will go in as part of the record because it's admissible. But it's only once you've got that threshold. And the other point I want to make is that those rulings on trials within a trial are what we call interlocutory. It means they can be revisited at a later stage. And JP may be aware from one of my judgments in the Murphy matter that I actually did reconsider an interlocutory ruling at the end of the trial before judgment. What had happened was that...
I think that's fine. I'm satisfied with the answer.
You're satisfied?
Yes. You wrote a judgment, my last question, S versus Cruz, that where the accused required services of a sign language interpreter. You highlighted that judicial officers have to be vigilant and because of insensitive to the great diversity of within the deaf population. Perhaps can you share your views of the importance of language in courts and how courts can be vigilant and practical in implementing, different languages?
Well, I think it's absolutely imperative to satisfy yourself as a judicial officer that the witness can understand the proceedings, or perhaps it's the accused. But the parties in the court you must be satisfied that they understand the proceedings. Now, we have provision for interpreters, but I think one must be vigilant. And if you get the sense that it's not working, you've got to step in and intervene. I mean, the Cruz case was an extreme example of a hearing impaired person, and their rights were just not respected because their particular challenges and difficulties weren't heard and weren't catered for. You need to be responsive. I would say that you need to be responsive. I know the official language of the court is English, and so we have interpretation, and I suppose that is. But I can say that in the Western Cape, very often, people will want to testify in Afrikaans, and if everybody in the courtroom is okay with that, I have allowed it on occasion. Sometimes the interpreter interprets and then the witness jumps ahead of the interpreter and then it becomes a bit of a mess. And then sometimes I just say, well, let's go ahead in Afrikaans. My answer really is that you've always got to be vigilant to make sure that the people in your courtroom are being heard, are being understood, that they feel that they are being heard and understood, and that they can participate in what is going on in the proceedings.
Thank you.
And that's what you need to do.
Thank you, Ms. Davis. Thank you, Chief Justice.
JP, Advocate Boshoff.
Thank you, Chief Justice. Morning, Advocate Davis.
Good morning.
I just, with the Chief Justice's indulgence, I have two questions. One a technical question and one a more general question. So I think just from a technical point of view, recently the Constitutional Court has grappled with the issue of Section 10(2) of the Recognition of Customary Marriages Act, insofar as it allows for couples married in terms of customary law later to choose, who then later choose to conclude a civil marriage in terms of the Marriages Act, and potentially then allows for a change in the matrimonial property regime without compliance with Section 21 of the Matrimonial Property Act. Are you familiar with this recent Constitutional Court judgment?
I must confess that I'm not, but having heard from you, I will go and make a point of looking it up.
Right, yeah, because the court there dealt with the fact that Section 10(2) didn't expressly incorporate Section 21, which requires judicial oversight of a change in matrimonial property schemes, and a notice to creditors, and whether or not that rendered Section 10(2) unconstitutional or not. And it was quite a close split in the Constitutional Court, with the majority narrowly taking the day. But okay, I don't think there's any point in going further because the question is quite pointed at that case. My other question is just, earlier in your interview, you said as you made the move to the bar, you said, boy, was I wrong about your expectations of life at the bar initially. Now, I might have misunderstood what you're hinting at, but having been at the bar myself, I've always grappled with this conundrum that the bar faces with being kind of an individual life, individually driven practice, but also being part of a broader association, and how there's this impression that if you're a junior and there's a senior counsel that takes a liking in you, your road ahead is much easier than somebody who has to essentially build something from scratch and just take whatever they can. Now, I don't know if you were hinting at life as a junior being that challenging and trying to actually build a practice, or what. So I just want to explore what you meant by that, because where I'm going with this is, what can the bar do to, beyond the current transformation imperatives, but also to build future talent in general, because, at the Western Cape government, we are very concerned, for example, with especially with the recent elevation to senior counsel of members of the bar, the next generation of juniors who would be doing work in, for example, public law and those things. So what do you think, and this is potentially not a question aimed at your life, potentially at the bench, but I think it speaks to the broader kind of legal fraternity, is how do we ensure that this carries on for the next 10 generations without, through pure self-seeking behavior, the bar essentially just culls itself from the next generation of leaders and strong advocates?
Well, to begin, let me answer the first point, which was what I meant. I meant nothing more than to say that I was young and naive and starry-eyed, and I believed that hard work and talent was enough. I didn't realize the reality that a lot of women have faced at the Cape Bar, that, and certainly when I started out, that it was almost impossible for women to develop a commercial practice. They were sidelined into family matters. Yeah, it was hard to get work. It was hard to build a practice. And many years later, when I was one of the people contributing and making comments on the reform of the silk application process, was I said that we need to broaden criteria because we are overlooking people who have got talent and ability, and who the size of their practice is not an indication of their ability. But, in those days it was, if you don't have a big practice, you're not going to get silk. It doesn't matter what you've done, even if the little bit you've done is of a supremely high quality. It doesn't matter if you're able. It doesn't matter if you get the qualification, you're going to be able to get opinion work because you are good. It didn't matter. You had to have a big practice. And I was one of the people who stepped forward and said, no, we need to broaden the range of competencies. Otherwise, we're never going to get diverse silk. And I always saw that diversity was important, because how else are we going to have a diverse bench? We need to have people coming up through the ranks. And that brings me to the next question. I believe, having served on the structures in the bar within the last couple of years, I'm not speaking for generations past. I only came onto the Bar Council in 2020, and I've had a couple of stints since then, and the LPC in 2023. I believe, hand on heart, that the will is there. There are transformation initiatives. But let me tell you, I've looked at the statistics, and the progress is achingly slow. And I can understand the frustration. And I sit here and I rack my brain, and I've had conversations with some colleagues, and I've said, what is happening? How can we change this? We are a referral profession. It's hard for juniors coming in. It's very hard to start off without financial backing. And the conclusion I've reached in consultation with some esteemed colleagues is we can't solve this problem in silos. We are working for a unified profession. We have the Legal Practice Act. And I would like to see a forum, whether it be a national forum, whether it start off as a provincial forum, perhaps the latter for starters, where you get all the role players around the table, the LPC, the Bar Council, all the BLA, NADEL, AFT, you get everybody around the table, and you start to thrash it out and work on collaborative solutions. Let's diagnose what are the problems. Let's diagnose what can we do? How can we fix this? But the one thing I can say to you as a member of the bar is the bar can't fix this on its own. It's doing what it can. but it's like plugging a finger in the dike. It's not enough. I read a very, very courageous piece by a young African advocate who qualified last year, writing in the Advocate magazine about starting off. And he said the same thing that I said. He came thinking that talent and hard work was enough, and reality bit. And he now advises other young people, don't do it unless you've got some money behind you, you've got some savings, or you've got some family member who can sponsor you. There's a bar transformation bursary, and it helps. It's not enough. So that's my answer. We can't solve this in silos. We need a coordinated approach from the whole legal profession. That's my answer.
Thank you very much. Thank you, Chief Justice.
Thank you, Advocate Boshoff. Minister? I don't have much of a question, but I just want to follow up on Advocate Boshoff, because I did pick up that as part of your work, Advocate Davis, good morning.
Good morning.
You do work and support Black female juniors in the commercial field. I do want to commend you for that. When we look at the profile and the diversity and the work that most of the time Black juniors and Black women trying to access, this is not one of the areas that they're able to get. So I thought, let me just commend you for that, because it's one of the key areas that I've been trying to get around as a minister. And to see somebody who does that work, it's commendable. Thank you.
Thank you, Minister. And I can just say to you that it's very close to my heart. And it was very heartwarming for me recently when I acted last term to see some of those young women appearing in my court, and they made me so proud. And I felt like a mother with her children coming home. I was so proud.
Thank you, Minister. Commissioner Moimang?
Thank you, CJ. Good morning, Advocate Davis.
Good morning.
The side.
Yes, I see you.
Thank you. That's building on the response that you gave in relation to the need to have a coordinated approach on addressing the challenges around transformation. The question that I want to pose is, because you were more direct on what is expected on the legal profession. Now, the question that I want to ask is, how do you understand the judiciary's role? The judiciary's role in advancing transformation, and then linked to that also, how do you safeguard your independence while remaining responsive to constitutional values such as transformation and access to justice?
Commissioner, I'm struggling to hear you, so I'm going to have to ask you to repeat those questions perhaps a bit louder for me. Sorry.
Okay, thank you. Am I audible enough now?
A little louder.
Thank you. The question that I want to ask is, how do you understand, because in your response to the challenges around transformation in the legal profession, you were quite outspoken. So now the question that I want to pose is, how do you understand the judiciary's role in advancing transformation? And then secondly, how do you safeguard your independence while remaining responsive to the constitutional values such as transformation and access to justice? That is my question.
Yes.
Thank you.
So I want to answer that by saying that for me, the bedrock is the Constitution. And I think that fundamental to a judge's role is the separation of powers. I am acutely aware that judges are not elected officials. We do not get elected by the population. So for me, that is very important. You got to stay in your lane. Those three arms of government mustn't stray. So the role for me of a judge is constrained by the separation of powers. Having said that, one must advance the values of the Constitution. One of those is transformation, clearly. But I believe very strongly that a judge cannot, under the cloak of their judicial function, seek to advance personal agendas, no matter how laudable they may be, because they are not elected people, not elected officials. Those initiatives must be spearheaded appropriately through legislation, which will then come before the courts and be interpreted and applied and enforced. So I'm very wary, shall we say, of judges taking an activist role outside the sphere of the separation of powers. In my last interview, I was asked whether I saw myself as activist or conservative, and I said activist, and what I meant by that, and I wanted to make it clear, is activist in the sense of interpreting legislation in a way that progresses, that advances, respects, promotes, protects, and fulfills the values and the rights in the Constitution, but always within your lane, within the separation of powers. And part of that then linked to independence is that as a judge, you have to be independent and act fearlessly in that role of applying the law and applying and upholding the Constitution and its values without yielding to popular opinion. You've got to be rigorously intellectually honest. And so I come back to the point that no matter how laudable, you can't advance your own agendas under the cloak of doing your judicial function. So I hope I've answered your question.
Thank you, Advocate. Thank you, CJ.
Chairperson, followed by DP Zondi.
Thank you very much, CJ. Good morning, Advocate.
Good morning.
You have had extensive acting experience. What systems do you use to manage workload in order to ensure timely delivery of judgments and also to maintain consistency across a wide range of matters?
I missed that one word. How do I manage my, was it load?
Yes.
Yes.
And also to ensure timely delivery of your judgments and or maintain consistency.
So it's a matter of hard work, first and foremost, of diligence. You do have to manage your load in the sense of prioritizing. So I gave an example earlier on of a full bench appeal in terms of Section 18.3 of the Superior Courts Act, where the Act says these have to be dealt with as a matter of extreme urgency. And so that got priority and that got done in a week. Well, that means that some other things get pushed out a little. But of course, you bear in mind your norms and standards to try and get them out within in 3 months. And I can say generally in the past, I was able to do that well within that time. I have 2 judgments that I delivered earlier this year. One of them was in 4 months and 2 days, and one of them was in 3 months and 20 days. And that is really just the product of workload, an increased workload. But I did my best, and I take so seriously the injunction to deliver judgments timelessly, because I believe justice delayed is justice denied, and I believe that our people are entitled to expect that. But as I mentioned earlier on, the division has some severe challenges in terms of being short-staffed and so on, and sometimes it just isn't humanly possible. But having said that, I don't think I could sleep at night if anything was outstanding for more than 4 months, you know. It's something I work at constantly.
Thank you very much for the response.
Thank you, Commissioner Mthatha.
Thank you. Thank you, CJ. Hi, morning, Advocate Davis.
Good morning.
During the presentation and in response to the question that was put to you by Advocate Bossov, you made a very compelling statement. You said that hard work and talent is not enough to get you some work. That is your experience when you started out in July 1994, and it will seem to me it is still your experience even today.
I would agree.
What might cause a problem? Why there is a resistance? What is the source of the problem, and what can be done to resolve that problem? Thank you, Sir.
Commissioner, I have racked my brain about this, and I know many other people have for many years. Speaking about the bar, it's a referral profession, so one is dependent on the work coming through from the ranks of the attorneys. Now, it has struck me that the problem, I think, is worse, more acute in the Western Cape than, for instance, here in Johannesburg, where there is an abundance of work. I don't want to speak for Joburg, but my sense is that it's easier to make a go of it here. And my sense is that women have had a much better shake of it at the Johannesburg bar than they have at the Cape. I see them excelling in all spheres of practice, and they don't seem to have been sidelined into family law and so on in the way they have at the Cape. And I also don't want to say that things aren't changing, because they are, slowly. I see encouraging signs of a lot of young women growing up in the ranks of public law. I think that's very encouraging. I see some green shoots in the area of commercial law. It's still very slow, though. I can't explain to you why it is that I lectured in insolvency. I knew my way around, but I didn't attract that kind of work. A little, but not that much. I can't explain these things to you. I don't know. I don't know the answer. I don't know what is the thinking. I don't know what is the prejudice. You know, it's so complex. People like briefing people they know. People have perceptions about who can do what. And there was a generation when there was a very chauvinist perception in the legal profession in the Western Cape. I mean, I can give you an example from the firm where I did articles. The senior partner didn't take a young woman professional assistant to a meeting with a big banking client. He took all the young men. Because why? Because he said, lady lawyers must stay in the back room and do damages claims. And that in a situation where they ran to her to do all the drafting of commercial contracts because she was superb, but they didn't take her to meet with the bank. Okay, that was then. I think things would be different now. But, you know, those legacies live on for a very long time. And that's why I said earlier on that I think we can't solve these things in silos. And I think they're difficult conversations that need to be had. At our bar dinner at the end of last year, JP Babinda Bokwana gave a very honest speech to the bar. And she said, there's some difficult conversations that need to be had. And I think she's right. But I don't think having them in the bar is enough. I think we need to have them in a profession as a whole.
All right, thank you, CJ.
Thank you, DP. Commissioner Matolo, followed by JP Tlali.
Thank you, CJ, and thank you, Advocate Davis.
Good morning.
Good morning. Good morning. Sorry, we're a bit tired. I'm quite amazed at, actually, I'm happy that you are raising this issue. And it's not only an issue of Black practitioners, but even white women practitioners are experiencing what Black practitioners are experiencing. But I think it's not a hard discussion. The issue is that, especially from the Bar Council, I've been doing stakeholder engagements about the legal sector code. What we find is that advocates are quick to say, client want me, client will dictate whom they want. And as long as we still encourage that, the client will always want what they're comfortable with, which is white and male. So the discussion is already out there. We are discussing about it. But I think we need to convince our own clients to say it can be that whites are the only people who've got capacity or who've got the skills. I always make an example of the Constitution. It came in 1994. Everybody, it's new. But suddenly, white males are experts. And we can't be experts. Then you want to understand, where did they get those expertise? They got the expertise because they were briefed time and again. So until we challenge the private sector, the government is doing their bit, but also, although they're still far from doing it, but we need to challenge the private sector.
That, I would agree with that.
Good morning, Ms. Davis.
Good morning.
Yes, here am I. Yes, I just want to put something to you just to get your comment. I know it's quite a difficult issue to respond to, which is a comment by the Advocates for Transformation, Western Cape in particular, that they got varying reports from their members. Some are positive, some are negative, and then they say they do not support your application. I don't know if you are in a position to respond to this comment, or you might know what is the elephant in the room. I leave it to you, but at least we put it to you so that you comment, and they shouldn't say you are ignoring their comments. Thank you.
Thank you, Commissioner. I'm not really in a position to respond to vague comments like, well, some say positive things, others say negative things. I know of no elephant in the room, truly. I do notice with some sadness that they say that they regard my efforts at transformation as not meaningful. And my response to that is, I respectfully disagree. And you've heard from the voices of the young women who I've mentored and involved in my work how much it has meant to them. And so they would disagree with that. And if I can just also share one story, they say what I've done isn't meaningful. But I can tell you about one young Black woman attorney who I got to know as a student while she was still a law student working in a store. We got chatting. She was encouraged to hear that I was an advocate and an acting judge at the time. Years later, she looked me up at the bar and started working with me. She sought my mentorship when she wanted to start her own firm with another young Black woman. And I encouraged her and I supported her and I said, you go, girl, you do this. And shortly before she'd already printed the invitations for her opening party, she came to me and said, you know, I've been headhunted by this established firm and they want me to come in, but they're only offering to bring me in as an associate. And I said, no. I said, you don't do it. I said, you go, you pursue your dream. You've got the makings of a successful firm here. You go. And I said, you know what? They'll want you later on, but then they'll take you as a director. And sure enough, not long ago, last year, I got a call from the managing partner at that firm and said, I want to talk to you about her. She's listed you as a reference because we're looking at taking her on as a director, but we're a bit concerned about fit and we're worried about this and that, but we want to hear from you. And I was able to speak from the heart with all the passion I have for that woman and the belief that I have in her. And I said, you would be a fool not to hire her. I said, she is a gem. And you know what? She told me later, as did the managing partner, that was instrumental in her being taken on as a director in that established firm, and she now heads up her own department there. And so I would say to AFT Western Cape, Ms. Erin Goliath will tell you that what I have done for her in her life has touched her and it means something to her. Thank you.
Given your maturity and experience, if appointed, this will never affect your thinking and adjudication of cases. And the same, I take it, will apply to John Dickerson SC.
Mr. Commissioner, one must expect as a judge, it goes with the territory, that there are going to be complaints. It's part of being accountable. I have answered the complaint by Mr. Dickerson. There's no foundation. It's based on opinion. It's unsubstantiated in fact and law. And it's part of an ongoing matter. So although if I'm appointed, I won't be involved anymore, but I don't want to say any more about it. I just want to say that the judge who presided in that matter made absolutely no adverse comments about me, about the same accusations that were put to the commission about me. So that's laid to rest. But more than that, I want to say that you got to rise above these things. If you're a judge, you must expect it. You're a public official, you're accountable, the public are entitled to complain, and you've got to answer for yourself. And you can't get personal about it, and you can't be thin-skinned, and you can't take umbrage. You've got to deal with it. It's part of the territory. And so I like to refer to what Michelle Obama once said, when they go low, you go, when they go low, you go high. I'm not suggesting that complaints are going low. No, that's not what I'm saying. But what I'm saying is you rise above it. You rise above it for the integrity of the office and your calling as a judge, and it's bigger than you yourself. It's not about you. It's about the office.
And the integrity of your colleagues as well.
I beg your pardon?
And the integrity of your colleagues as well, because we've got a collective integrity.
Yes, absolutely.
Yes,
absolutely.
Thank you, Mr. David. Thank you, CJ.
Chief Justice, can I just, on that point, I don't know if the Objections Committee just want to also put a ribbon on it.
There's no objection against it, no standing objection against it.
Yeah, but they've dealt with it and found it without merit. So I just wanted to at least clear the air on
The
it.
fact that it has not been raised means that there's no issue.
Okay. Yeah.
Okay. Commissioner Jivan?
Thank you, Chief Justice. Advocate Davis, the other critique from Advocates for Transformation says that, which you probably read, it says that your appeals, the cases taken up on appeals were particularly relating to statutory interpretation in 2 of the 4 matters, and that you granted leave to appeal. However, no SCA judgment contains adverse remarks regarding the applicant. Would you like to comment on your error in statutory interpretation in 2 of the 4 matters?
Yes, Commissioner, I'd like to say that of the 4 reversals on appeal of my judgments, 3 of those judgments were penned in my very first acting stint. One of them was penned later in about 2018. It was reversed in 2020. I do my best, but judges are human, and I think with statutory interpretation particularly, it's sometimes hard. It's open to different interpretations, and judges do disagree, and that's precisely why we have appeals. But having said that, particularly in the one SCA matter, I've studied the judgment, I've taken it to heart, I've taken it on board, and I've learned from it. I said, well, I won't make that mistake again. And I think I've grown and I think I've developed. And that's all I can say. I can't promise that I won't make more mistakes because, like I say, we're only human. But what I can say is that I'm humble enough to take correction and to learn from my mistakes.
Thank you. I understand the interpretation part, and that most even seasoned lawyers will happen. Thank you.
Commissioner Kwanazi. Thank you, CJ. Good morning.
Good morning.
AG.
Good morning.
Yes. Look, I read your judgment on that crazy matter. I think I'm happy with how you were able to at least come out clear on the effective communication that is required in the judicial sensitivity. I think you made that clear. I want to take the point further that when you look at the effective communication and these dense legalese in the courtroom or pleadings, do you think if we were to stretch the effective communication, we need to do something about the language that is strongly reflective of complex legal language?
If I'm understanding you correctly, Commissioner, you're saying that we need to work harder at making language accessible and less full of jargon and less technical. In other words, to make it more accessible, if I understand you correctly. And if that is what you're saying, I'll wholeheartedly agree with that. And I think that that's an ongoing process that I think all judges need to be mindful of, that our audience is not just lawyers and judges. Our audience really at the end of the day is the litigating parties in front of us and the broader public who want to read and understand. So yes, I'm a great advocate of simplicity in language, simplicity in concept. I always think that, I think it was Einstein who once said this, if you understand something well, you can explain it simply. And if you can't, that means you don't understand it yourself. And I think we need to take that to heart as judges. We need to work at unpacking and explaining and simplifying concepts so that they become accessible. That, I hope I've answered your question.
Yes, you did. Just last question again, Jay. The previous time that you were here before the commission, you traversed the issues of transformation, which Commissioner Lipo raised even now. I have no intention of rehashing those issues, merely to find the progress that has been made on the issues that were raised about briefing patterns from that period up to where we are now. If there is progress or positive movement, then we are able to share that. But if there are skeletons as well, share them so that we understand exactly what is the current position. Thank you.
Commissioner, I have no skeletons. I'm an open book, and I've put before you the work I've done, the work I've done with Black female juniors, the work I've continued to do in education, in legal education and pro bono. I have nothing to add.
Commissioner Poso.
Thank you, Chief Justice. Good morning.
Good morning.
Good morning, Advocate Davis. I have heard the problems that you have expressed about the briefing patterns, etc. at the bar.
I beg your pardon, Commissioner, I'm struggling to hear you.
I say I have heard the problems you have expressed about the briefing patterns at the bar and the lack of transformation. I think the matter has been discussed ad nauseum. And if you really look at it, it seems that the bar is not about transformation, but assimilation. If you do not get to the bar and behave in a certain manner and act in a certain manner, then you will stay where you are. The bar is not about diversity, especially the Western Cape bar. And I think that's really it. Anyway, my question is about the anti-sexual transformation.
It's been a long week, Commissioner.
Your pardon? It's about the anti-sexual harassment policy. That, are you aware of it? Have you acquainted yourself with it? Did you send any inputs on it to the committee or the Office of the Chief Justice? Or do you think it is fine in its current form?
I'm aware of the policy. I've read it from cover to cover. I welcome it. I think that sexual harassment is an absolute affront to human dignity, and it has absolutely no place in the judiciary. I am very impressed with the policy in its current form. I am particularly impressed by the sensitivity and victim-centered nature of the policy. I welcome the fact that it gives a choice to the victim to proceed at different levels. You know, I like the fact that it's a beginning level where the victim can request engagement and intervention. That's almost like mediation, to say, you know, I want to tell this person that what they're doing and what they're saying is making me uncomfortable. And what I like about that is that it then also plays an educative function. Because I think that a huge part of the problem is that we need to transform the culture in the workplace. I think there's a tremendous amount of education to be done around this. And I see this policy as a vehicle of driving that sort of education. And of course, the policy provides for escalation if necessary, and for dealing with recalcitrant people, and for dealing with the most serious and egregious instances of it. So in short, I think it's a wonderful policy, and I welcome it and I salute it.
Thank you, Chief Justice.
Anyone else? You were here in 2013 as well, you did apply for appointment.
I beg your pardon, CJ.
No, I'm asking if you did not apply for a position in this very division in 2013.
I did.
You did. Are you that
my
Davis?
fourth time. I applied in 2013 and 2014, and then again in 2019. And this is last chance saloon because I'm proudly 61.
I thought it was your third time, and I was
It's
going
my
to say,
fourth
well,
time.
hopefully third time lucky. Well,
No, it's my
hopefully
fourth
fourth
time.
time lucky. Thank you very much, Advocate Davis, and for your patience. I know you've been here. This is your third day in Johannesburg. We do apologize for that profusely.
I want to thank the commissioners. I felt very, very sorry for you all last night. It was late, and I was acutely aware of how tired you must be. And I want to thank you for all your hard work and your attention and your time.
Thank you very much. You're excused.
Thank you. And have a good day, and I hope you finish on time today
Thank
to
you.
get home. I
We are just waiting for the JP.
No problem.
I don't think she'll really miss anything. Good morning, Ms. Yonke.
Good morning, Chief Justice.
How are you?
I'm well under the circumstances.
All right. Let's start then. You hold a BA law and an LLB degree from Stellenbosch University.
Correct.
And you were placed third on the Dean's merit list for one of them, one or both? Which one?
Yes, it was for my LLB degree.
Well done. You were admitted as an attorney and notary in 2004.
Yes.
And as a conveyancer in 2007. And all these things happened whilst you were with one particular law firm, named
Yes.
Shapiro and
Smith.
and Smith. That's where you did your articles of clerkship, and that's where you've been throughout your entire career, not so?
Yes, Chief Justice. I had one break in my career at Mindy Shapiro. I moved to another firm, thought the grass was greener, but went to go eat the grass and came back because home was where I started.
Yeah. All right. Oh, there's something I wanted to do at the outset. Maybe let me do that now. Just to place on record that you have disclosed in your questionnaire that you do a lot of work for the Democratic Alliance.
Correct.
And just to avoid any perception of conflict of interest, the DA representatives in the JSC recuse themselves from these proceedings. Happy with that?
Thank you.
All right. Let's carry on then. So you were still telling us that there was a break?
Yes, and then I returned home, so to speak, and I've been there ever since.
All right. And you worked your way from candidate attorney to director today?
Yes.
All right. So it's been what, 24 years? You've been with this firm?
But I'm not grayer is a miracle.
Yeah. You describe your practice as one split mainly between administrative law and constitutional law with a smattering of commercial and family law matters. Is that right?
Yes, Chief Justice. I've had a whole variety of exposure throughout my career. I didn't always start at admin and constitutional law. I inherited that when Mr. Mervyn Smith took me under his wing and, in a certain sense, exposed me to that type of law. Before that, I had a general litigation practice stemming from a whole host of civil matters, some small criminal matters. You do what you do when you're an attorney. The clients, you can't always choose. You're not always in a position to be selective. And you try and get as much exposure as you can. And then I was fortunate enough to get involved in the type of litigation that I do today.
And in this long career at this law firm, you've appeared frequently at the SCA and in the Constitutional Court.
Yes.
I think you may have appeared before me.
Yes, Chief Justice. I've been really blessed to have been exposed to all the high courts in South Africa and the appeal courts and the Constitutional Court. I haven't appeared in myself in the SCA or the Constitutional Court, but always as an
I
instructor.
mean, you were part of the team.
Correct.
Mhm, yeah. And in the electoral court as well.
Yes.
You have served as a small claims court commissioner since 2020.
Since 2010.
Sorry, what did I say? 2010?
Yes.
I'm actually looking at the thing. That is commendable. I'm always excited when I see that these practitioners actually take time to plow back, because that's plowing back. There's no money in our legal representatives in that job.
Yes, I serve as a small claims court commissioner in the area where my firm is, and because I grew up, if I can call, for lack of a better understanding, in that jurisdiction, it was obviously the court that I would wanted to approach to serve the community, the litigants that just cannot afford getting attorneys on board, and it's very touching to sit there and listen to their problems, try and solve it, and walk out there and they've actually resolved their own disputes.
And you've lectured candidate attorneys for over a decade now.
Yes, I've got a little bit of a closet teacher in me.
I see that.
I really enjoy lecturing, and I feel it's something that a practitioner, it's very close to my heart because I give them real life experiences. When I studied at varsity, the two subjects that was the most important is not prioritized as much as I think should be, civil procedure. It's exactly that what candidate attorneys do in practice, but they don't get that exposure. So I'm trying to bridge that gap by lecturing on that subject as well.
Yeah. And you take interest in your community as well. I see that since 2002, you've been involved in one association or the other, community association or the other.
Yes, Chief Justice, I'm always the one, I like raising my hand. I feel you can't just sit and watch, you need to get involved. So if there's problems, help get those solutions. And that starts within your own community and the schools, the church, any community-driven projects.
You have acted at the High Court, this division to which you want to be permanently appointed now.
I have,
yes. Starting last year into this year.
Yes, Chief Justice, my first stint was in April last year, was for a short, brief 3 weeks. It came as a big surprise. It was a very big honor. And I then was approached by the Judge President again, and I acted in the third term, 2 weeks shy of the full term. I made those 2 weeks up with part herds that I had to finalize, and then I acted in the first term of this year.
So how long in all is that?
22 weeks.
22 weeks, all right. And in which courts have you sat during this stints?
I have had exposure to everything. I have sat in full courts, full bench, appeals. I had a criminal trial, which is still the evidence has been completed, but it's still running. And I have sat in motion court 5 times. I have done urgents. I always ask that I can sit twice in the week, that I'm on motion court duty. I've done 4 civil trials. I have had exposure to what that division can throw at you.
Appeals?
Yes.
Criminal and civil?
Yes, both.
You spoke of one criminal trial. Am I right in assuming that that's the only one you've had an opportunity to be involved in?
Yes. And I was fortunate enough that it could be finalized in the first term. We are just hearing legal argument next week.
You have not had any difficulties managing that criminal trial, because I see that in practice you've not had much criminal experience,
Chief
criminal law
Justice,
experience.
no, I was very comfortable in the running of the trial. We had great briefings by the senior judges that are very much the leaders in that area. I was very comfortable. I've got a very good foundation. I understand the law of evidence. I understand this Criminal Procedure Act is a very helpful act. It guides us very well. So I've been very comfortable in it.
And in this time, you've managed to write judgments.
I have.
How many in all?
I have counted 29 judgments, of which I'm proud to say I have one report.
Oh, I know that feeling. Just the one.
Just the one because.
Well, it's only that I'm not underestimating it by any means.
Yes, it's reported. It's going to be reported in the April South African law reports. I got the notification that it's reported.
Congratulations.
Thank you.
You don't have outstanding judgments.
Chief Justice, I have two matters, one of which I've written, it's with my senior judges, and another matter where I was not the scribe, but that's all within the 3-month period.
The law professions generally, the law bodies generally support your application, except for two. Advocates for transformation in the Western Cape who say your application does not demonstrate a serious commitment to the transformation of the legal profession. And then there's the BLA, I think. It is the BLA. No, it is Nadel that says you need, you have not acquired quite enough judicial experience and could do with a bit more acting before you come back. And they also express concern about your involvement with the DA and want us to find out if you would be capable of being impartial in politically charged cases involving your party, I imagine.
Yes. I have taken note of those comments, Chief Justice, and I can answer them as follows. The comment of Western Cape, it's short, just one sentence, and I suppose I understand why. I am a white person, but I am also a female, which will contribute to the transformation of the bench. Furthermore, I have, on transformation, I think there is no doubt that I have contributed to transforming. In my practice, I have contributed to transforming briefing patterns. I have clearly shown in my profession or approach to my career that is a value that I really live by every day. I have support in my application. I've attached support by various counsel, one of which is a black female junior in Johannesburg, who I started briefing when she was still fresh out of pupillage, and she has confirmed that I approached briefing her not just as a tick box. She was briefed on her own in her first year. I can confirm that I support black female juniors quite extensively, to such an extent that when I pull them in a team, which I'm very fortunate of, my client supports my election of teams, that they have grown great relationships with the senior counsel that they've worked with. They get briefed, they get pulled in by the very same seniors to this day. Then I
In fact,
also
one of the silks who have nominated you, Advocate Jamie,
Yeah.
confirms what you say and says you've employed a number of black and female candidate attorneys,
correct.
and with whom he's also had an opportunity to work, and that relates to what you say now, that they've developed relationships
Absolutely,
with this
Chief
senior
Justice.
counsel.
I don't. I'm part of a firm, so it's a firm approach. We've taken a conscious decision that that's what we want to do as a firm. We have produced fantastic attorneys, some of which maybe didn't stay in practice, but they've got flourishing careers in corporates. We've got one in academia. We have recently, I saw on LinkedIn, one of them have now joined the Nelson Mandela Foundation. So we're proud of what we've produced in our firm. We invest in our youngsters. We have a recent candidate attorneys that arrived at our firm without driving licenses, which is it's a common thread that we pick up in practice these days. And it's quite easy to drive an Uber rather than get that license, but it's quite empowering to get that license. So we have assisted our candidate attorneys to get the licenses. So they're driving around all over town. I don't think I'll venture a lift with them yet.
You probably won't mention this yourself, but it is said that you have pay tuition fees for underprivileged university students.
Yes, Chief Justice. That came about several years ago, where we met a black African man who, in a way, we got to learn from his story, and he told, and myself and a group of friends, we just decided that this guy shows real potential. This is a setback that he has endured. We need to assist. And he went to, I think it was Technikon at that point, and he succeeded. So we're very proud. I'm very proud of that. It's not something that one always talks about, but it's a way of life. It's you've got to pay your good fortunes forward.
Of course. All right, I'm going to allow JP Mabindle-Poqwana to put questions to you.
Thank you, Chief Justice.
And perhaps I should caution, I've already cautioned the commissioners not to ask unnecessary and too long questions, because we still have a long line of you to interview. And I want to extend this caution to you as well. The shorter your answers are, the quicker you'll be out of here.
No problem. Thank you.
Thank you. Thank you, Chief Justice. Morning, Ms. Yonker.
Morning, Judge President.
I think maybe let me cut to the chase in the interest of time. I just want to pick on one of the questions that the Chief Justice asked about transformation and support of counsel in the profession. On page 148 of the PEC, I don't know if it's page 44 up there, and it's page 148. You have a letter of support from Advocate Lerato Zikalala.
Yes.
And one of the things she says is that one of the very first briefs I received as an advocate, shortly after signing the Red Book at the end of my pupillage in 2017, came from Elzan. And then at the end, she says, the work that came from you constituted 40% of her workload in that crucial first year. What makes you trust people that other people would not trust as people that are new players in the profession, but you give them work? What makes you do that?
Well, Judge President, one has to give a person an opportunity to show you who they are. As an attorney, it's not a mere legal brief. You build relationships with those that you brief. You need to get a liking in them. You've got to see who they are. And I was fortunate enough to meet Lerato as part of a very good team, and she just blew me away. She was amazing. These days, when I try to brief Lerato, she's very busy. So, and I'm grateful for it. It's fantastic. I can't take credit for all the credit, or not even half of it, of what she's achieved. She's received an opportunity and she blew everyone away. She's an amazing advocate, and there's a lot of Black females out there that have got that potential. They must just get the opportunity.
In addition to your acting stints, you also attended the aspirant judges course. How did you find that?
I found it extremely helpful. It was a very well thought through program. It touched on subjects that an acting judge faces on a daily basis. It was it was a lot of fun. There was a lot of humor. It made the whole setting relaxing. You could take in so much more, and it assisted me tremendously.
We've noticed that you tend to deliver your judgments quite quickly.
Yes.
In your pack, you've submitted a few of them. One was heard on the 28th of July and delivered on the 7th of August. Another one was heard on the 20th of August, delivered on the 22nd of August. And the list goes on and on. How are you able to deliver your judgments that quickly? And those judgments also indicate that you engage with the issues and reason them quite well. How do you manage to do that?
Thank you, Judge President. The art is in preparation. It's one of the values that I've treasured from the day I started my articles. You cannot do justice to a client or a litigant if you yourself are not prepared. And in that preparation, you've done half of the work. So after you've heard a matter or a trial, you go back, you put it all together, and it should not take you that long. The longer it takes, the harder, I think, it becomes to write. Not that I'm underestimating the workload that can be thrown at you. I've felt that at the division, but preparation is key. And that gets you very far in writing judgments expediently.
And you've been involved as an attorney in matters that have changed the legal landscape and that dealt with constitutional matters. You've listed them, so I won't go through all of those. So you'll be familiar with administrative law and constitutional law and self-reviews. Can you tell us more about self-reviews? What principles are involved in that?
Yes, thank you, Judge President. So an organ of state is obliged to bring self-reviews, but the Constitutional Court has determined in the Gajima case that they cannot bring that self-review in terms of paja. They can bring it in terms of the principle of legality.
Okay. I think the last question would be about criminal law.
Yes.
You've done a criminal trial. If an accused applies for a discharge at the end of the state's case, what are you required as the court to consider in determining that application?
To be honest, in my criminal trial, I've also been faced with that. It's when there's no evidence that a reasonable court sitting would be able to convict the accused. That was produced after the state's case.
That's all I'm going to ask, Chief Justice.
Advocate Boshoff.
Thank you, Chief Justice. Morning, Ms. Jonker.
Morning.
Yeah, just a technical question from me. Are you familiar with the Constitutional Court decision in Essel Frankie pipeline, the Mupani District Municipality?
I can recall that being.
Okay. So the question isn't specifically about the case, it's just the issue that arose in the case.
Yes.
So can you please explain whether a tenderer may sue the state in delict for pure economic loss or lost profits caused by intentional or unlawful administrative action in a tender process? And if not in delict, can such a claim be sustained under PAJA?
Well, I've not been confronted with that, but if the recent case law has determined that if a tender has been set aside, the court will be able to craft a just and equitable remedy to restore what has happened, and that there is a possibility that the tenderer, depending on the facts of the matter, can be refunded with expenses, not profits. It depends on the facts of the case. So a tenderer would have recourse in those circumstances.
Yeah, I think what you're describing is in part the so-called no loss, no gain principle. But I think the question here is more to do with, given Section 8 of PAJA dealing with the ability to also compensate somebody who's been on the receiving end of unlawful administrative action, where the subsidiarity then essentially denies the ability to claim in terms of delict.
Yes.
And the courts essentially confirmed that subsidiarity, similar to the Kajima reasoning, you're bound to find your relief within Section 8, read with Section 172.
Correct.
All right.
You're stuck with what the legislation provides.
Okay. Thanks. That's all from me, Chief Justice.
Thank you, Advocate. Commissioner Steinberg.
Good morning.
Morning, Commissioner.
Just to declare that I have worked with Ms. Jonker from time to time. I recall the first time you briefed me, and you had brought me into a matter where there was already a young man from Cape Town on brief. And I said to you, I'm happy to do it, but I'd like to brief a young black junior from the Joburg bar. And I said so with some trepidation, because I have been met with strong resistance from attorneys when I say that. And you embraced it 100%. And that is how we worked since then. So I just want to add that. That is absolutely my experience of your way of working. And we have worked a few times with another Lorata, I think, who's going to bloom in the years to come.
Absolutely.
So thank you for that.
Thank you, Commissioner.
I wanted to ask you, I was intrigued to see the work you do at the Magistrates Court. And I just wanted to hear more about what that entails.
On what?
You had said you're responsible for the Magistrates Court portfolio, regular engagement with magistrates. What is it that you do?
Yes. So, Commissioner, a couple of years ago when it was still the Law Society, they had specialist committees. They had a High Court committee, a Magistrates Court committee, and as a member of the Tygerberg Attorneys Association, my portfolio was the Magistrates Court portfolio. And we sat on the specialist committee of the Law Society, where all the clusters, the Cape Town, the northern suburbs, came together with the Law Society. And we discussed and problem solved various difficulties that the Magistrates Court experience. And what that entailed was meeting with the magistrates of our cluster on a regular basis. The magistrates could communicate difficulties with us as legal practitioners, and we can then communicate with them. So it was an approach of, let's get the Magistrates Court working well. At that point, there was a lot of backlogs on default judgments, because that was still when the clerk of the court was seized with that. And they have limitations, and life is not easy in the Magistrates Court. They are burdened to the hill. And it was a way of practitioners helping them with getting the flow going.
Just briefly, I'm intrigued by your costs order in the body corporate of the Primavera case. Could you just talk to that briefly?
That was a matter where the body corporate approached the court to regularize their exclusive use areas. The respondent was an older gentleman who represented himself. It was quite a touching set of facts because he purchased his property believing he had all of these exclusive use areas. It ended up not being lawfully awarded to his section. And I, at the end of the day, regularized and found that the exclusive use areas was not lawfully allocated to him. But I found that it was unreasonable and not just for him to be saddled with a cost order. He did nothing wrong. He just, for 20 years, everyone acquiesced with his use of these areas. And I felt that he shouldn't have been burdened. He was already burdened by a special levy in the body corporate coming to court.
Thanks, Chief Justice.
Thank you, Commissioner. Professor Benham.
Thank you, CJ. Still morning. Good morning, Ms.
Morning, Commissioner.
Younger. Firstly, I just want to commend you for your impressive portfolio on constitutional law cases. You've done very well because they really shape our constitutional law jurisprudence.
Thank you.
Not that I agree with all of them as an academic, but the GCP commends your judgments as lucid and demonstrate that you can articulate yourself well in writing. I just wanted you to take us through your judgment writing process. What informs that?
Thank you, Commissioner. So my process, as I've indicated to the Judge President, is the preparation. So once you've done your preparation, you're quite halfway through your judgment. So you would, as the division quite frequently holds inductions for acting judges, we were told and taught that Lefario is the method of drafting your judgment, which will just start off with just introduction, what the matter is about, what the facts are, what's in dispute, what the legal framework is, what's the analysis and your conclusion, and of course a cost order and your remedy.
Thank you. Thank you, CJ.
Thank you.
Thank you, Prof. Commissioner Moimang.
Thank you, CJ. Good morning.
Good morning, Commissioner.
The question that I want to ask relates to what the CGS raised around you being the attorney of record for the Democratic Alliance in many cases.
Excuse me, Commissioner.
I'm saying that you being associated with the Democratic Alliance
yes.
in many cases.
Yes.
It's not a matter of one or two. I'm looking in most of the divisions
yes.
from the Concord, East 11, Supreme Court of Appeal, also Western Cape, Gauteng, Northern Cape, which to a larger degree poses the perception of bias, which can be as damaging as actual.
Yes.
Of course, the JSC has dealt with such cases in the past, but now the question that I want to pose is whether have you not considered a cooling off period for your firm to represent the Democratic Alliance so that this perception to a larger degree is mitigated. I'm raising this point because the fact that even the members of the DA who are part of this commission have recused themselves, it means definitely it is not only just a perception, it is actual. So have you not considered a cooling off period for 2 to 3 years representing the Democratic Alliance so that you are then able to mitigate this perception of bias? Thank you.
Thank you, Commissioner.
May I follow up? I think perhaps the question should be rephrased. How will you, as a judge, if you are appointed to a permanent post as a judge, how will you assure the public that you will not be biased in favor of the DA? Or how will you deal with matters concerning the DA if allocated to yourself? I think, yeah.
Thank you, Commissioner.
Thank you.
I expected that question, so thank you. I don't hide behind that I've been acting for the Democratic Alliance for a good part of 15 years. Having a client, you build a relationship with them, and it's a relationship of trust. But I've, at all relevant times, acted for the Democratic Alliance as an independent legal practitioner. I've never been involved internally in the DA, and to act for a client on an independent level, keeping my independence and impartiality away from the internal workings of the party, I think goes a far way into establishing that I will be impartial. There's several grounds that I can also state that there's been several legal practitioners that have been elevated to the bench that has acted for political parties in the past, for government, against government. There is no reason to believe that they can not bring an impartial mind to the matter that they've got to adjudicate. I've taken note, and whilst I was acting, when a matter of my firm, who regularly litigates in the Western Cape, matter came before me in motion court, I would take the liberty of asking my colleague who sits with me in that motion week to please attend to the two matters. And what I would do is in court call the matter, because the defendants or the respondents would be there, and advise them that the matter would be dealt with by my colleague. Of course, one has to appreciate that if I am appointed, that there will be a period that I will not act for or be presiding over matters from my firm, purely because it is a reasonable apprehension that I would notionally be biased. Not that I would be, but it's about the litigant on the other side. But with regards to politically charged matters, there is no reason to believe that I will not bring an impartial mind to that. On that score, there's a lot of great justices that has come from acting for political parties. And that criticism, unless a specific matter and specific facts by a litigant making out a case for my recusal, of course one would have to entertain it. And they'll have to pass the test. But I firmly believe that that is not an impediment for me to impartially adjudicate a matter. With regards to the question about a cooling off period, it's quite a difficult situation, because as a practitioner, you cannot, my practice consists mostly of that client, and to tell the client, you don't do a justice to that client as well. We've got a professional relationship. There's no one in my firm itself that I can delegate that practice to, because it's quite a specialized field. But I do take the point, but I do confirm that I don't see an impediment should I be elevated.
Are you a member of the Democratic Alliance?
No, not at all.
I will allow you.
Thank you, CJ. Have you acted for other political parties?
Yes, I have. I have acted for several other political parties.
Can you tell us which parties you've acted for?
I've acted for the ACDP. I have acted for community forum parties on local government level.
In the resume, it lists economic freedom fighters versus Speaker of the National Assembly and others.
Yes, that's just big. It's the Democratic Alliance intervened in that application, so the citation would show the EFF as the litigant.
Thank you.
I asked you if you are a member of the DA, because you're absolutely right. There are practitioners who have ascended to the bench, who had ties with one political party or the other.
Yes.
And I do recall recent memory, one such practitioner who did a lot of work for one particular political party, but was also a member, came to the JSC, applied for a position in one division of the High Court, but was turned away and asked to just take a breather.
Yes.
So he did not make it that first time. He had to come back on another occasion and prove that he had taken a cooling off period.
Yes.
But he was also a member of this party.
Chief Justice, I've made a concerted effort over the 22 years that 24 years, I think, that I've practiced, not to do that. I've never been affiliated with any political party because of the fact that I want to be independent as a legal practitioner.
Right. Advocate Boshoff?
Thank you, Chief Justice. Yeah, just briefly on the cooling off period from a practice point of view, I mean, would it also not bring into question serious ethical issues if you were to say to your client, look, for 2 or 3 years, I can't, and my firm can't represent you because I have personal aspirations to become a judge?
Yes.
I think that's an impossible position then to place yourself into, whereas, as you remain an officer of the court, even in your work with that client, you have an obligation ultimately to the court to be honest and independent in how you guide your client's litigation.
Absolutely, and I've always maintained that. And my clients have not always liked my advice, but I give it to them, truth to the law and to the facts at hand. As a judge, that is what I will do. I will apply the law to the facts and irrelevant of who the party is before me.
Thank you, CJ. Still morning. Morning, Ms. Yonka.
Morning, Commissioner.
My question relates to the cost that you, deponis propis cost that you imposed in a matter concerning the setting aside of irregular proceedings. It's redefined properties LTD and versus Masikame Trading.
Yes.
It's you ordered the defendants to pay cost, the defendants' attorneys to pay cost out of their own pocket, including costs of counsel. But it's not clear for me the basis upon which you impose that court order.
Thank you, Commissioner. The reasons do reflect in my judgment. That was a matter where the plaintiff, the defendant sought a notice of intention, or filed a notice of intention to amend his plea. There was an objection to that notice, and accordingly, an application was made to court. The court then granted the plaintiff's attorneys withdrew their opposition to the application, and the court granted leave to amend accordingly. The attorney for the defendant in that matter then proceeded to effect an amendment contrary to that which the court ordered. He did so without notifying the plaintiff's attorneys to the extent of which he deviated from that or court-sanctioned amendment. When he filed the amended document, which he was authorized to do in terms of the court order, it patently differed from that which the court ordered. The plaintiff's attorneys indicated that to the defendant and gave them an opportunity to withdraw the affected amendment and proceed to file the corrected one. He summarily refused. He then proceeded to maintain that he is entitled to do so, despite the fact that the court did not order that. So the defendant's attorney proceeded with the notion that it doesn't matter. He had that approach. In argument, it was taken up with him in a quite an extensive way, and his explanation, as is clear from my judgment, was unsatisfactory. He took frivolous points to get past why he was of the opinion that it doesn't matter that it differed from the court-sanctioned amendment. There was ample times for him to retract. He didn't, and I saw that to be no reason to mulct his client for his refusal to follow the rules. It wasn't even a difficult situation to comprehend. He was not allowed to do that. And he caused a whole opposed motion to be run because of his refusal to comply with a court order. So there was no reason for me to find that his client must be saddled with that cost order, because his client isn't the legal person knowing what the court sanctioned the attorney to do at the end.
All right, so in other words, there was something that was, well, the conduct of the attorney is something that needed to be sanctioned.
Correct.
That was the purpose of your order, to sanction the defendant's attorney's conduct.
Correct, and not saddle the litigant.
All right, thank you. Thank you.
Thank you.
Thank you, TP. Minister?
Thank you very much. Thank you very much, CJ. Good morning, Advocate John Kerr.
Good morning. I don't think
Oh, sorry, Ms. John Kerr. Just to, my apologies about that. Just to look at your profile, am I correct to indicate that you've not acted as a magistrate? You do not have quasi-judicial experience?
I do,
You do?
Minister.
I might have missed that one. Maybe
I'm a small claims court commissioner, which I think is...
Okay, I don't know how I missed that
No
one.
problem.
Okay, and then you started acting last year?
Correct.
So maybe your comments, the reason why I'm looking at this, because I was looking at the comments by one of the law bodies that you've not had enough stings on the bench and therefore needed more time on it.
Yes, Minister, I think it's actually the comments by the LSSA that for some reason don't think that I've acted in the division. I don't know why that is so, but I have for 22 weeks, and I have had exposure to quasi-judicial work for the past 15 years, independent of my litigation practice as well.
Okay, no, I wanted to verify that fact. Thanks.
Thank you.
Commissioner Kosa?
Thank you, Chief Justice. I have to take this slowly now.
It is a bit of a tongue twister.
Good afternoon, Advocate Yonka, or Ms. Yonka.
Good afternoon, Commissioner.
Are you aware of the anti-sexual harassment policy that was introduced last year?
I am.
Have you acquainted with yourself with it?
Yes, I have.
Do you think it is implementable in its current form?
Definitely.
Thank you.
Thank you very much, Ms. Yonka.
Thank you, Chief Justice. Thank you to all the commissioners for their time.
You're excused. Commissioners, we're running behind by a whole hour, and I propose that we forego tea later and that we stretch our legs in between candidates.
Good morning, Chief Justice.
I'm sorry to keep you waiting. I didn't realize that they had already called you in. We just took a moment to stretch our legs. We've had a long morning.
Yes, it has. And yesterday was quite long.
Oh, yeah, and the day before. It's been a rough week. You hold 3 degrees from the University of Cape Town, a bachelor, business science,
That's correct.
and an LLB and an LLM, and then you went to do another LLM at Cambridge.
That's correct.
Okay, what were the areas of specialty of these 2 LLMs?
Both of them predominantly in administrative law.
All right.
But
So,
maybe I must just explain the way that the Cambridge LLM works. You have to do 4 areas. So the one I did there was in the administrative law field, they called it judicial review. And then I also did, the 4 subjects that I chose were all subjects that I would be able to use in South Africa because I wanted to come back here. And they were an international sales type matter, a commercial insurance type matter, because our law is very influenced by English law, and then intellectual property. One of the reasons I chose intellectual property was because there was a world famous professor there, Professor Cornish.
all right. So you did your articles and then decided you wanted to join the bar, actually.
Yes, that's correct. It was
And-
always my intention.
So you joined the bar in 1996 and lectured simultaneously for a brief spell, I understand.
That's correct. At the beginning at the bar, briefs are thin, few and far between. If one looks at my fee book from back in those days, it was tiny, and I enjoyed the lecturing. It was a good experience.
I did the same thing too.
Yeah.
But then I see the business picked up because you quit your city in 1998 and focused solely on your practice.
Yes, it did. I'm a big believer in you're only as good as your last brief. I think that applies, and it's just so important to do everything properly. And I think another big factor is timelessly.
You took Silk in 2018.
That's correct, Chief Justice.
And you run what you describe as a commercial litigation, mainly a commercial litigation practice, which focuses on contracts, companies, insolvency and public law, and the like.
Yes, I would describe it best as a general litigation practice, Chief Justice. I think by its nature, practice at the bar, you'll have a general practice like that, or in addition to that, if you specialize in a specific field, you become part of that node. There are some clear nodes, and we get a very limited number of practitioners that at the bar that will practice in that node, like shipping, labor, criminal, etc.
You have served as a small claims commissioner for a number of years.
Yes,
Over a
that's
decade.
correct. Sorry, Chief Justice?
I was saying since 2014.
Yes, I think it's been for 11 years. And it was a big eye-opener for me, Chief Justice. It's actually one of the reasons why I've applied. I'm here today. Because it was a big eye-opener for me how important it is that the judicial officer, the presiding officer, the impression that it makes on the court. And there you've got people coming in, they can't be represented. Obviously, the figures don't warrant any representation. And it's a much more inquisitorial procedure where you need to help both sides with ensuring that they present the evidence properly. And I find when that's done, even though a result may go against a particular party, if you as the presiding officer have done the job like that, the appreciation of that, they obviously don't like the results, I'm not talking about that, but the appreciation that they've been treated fairly, it was amazing to me. It had a big effect And that was one of the reasons that prompted me ultimately to be here today.
Well, one of your senior colleagues who has nominated you describes you as a man of principle, and he attests to your commitment to the KPA's transformation initiatives, which include the second junior and fee sharing arrangements which benefit Black and female members of that bar. So I suppose that ties in with your commitment to serve in a body such as the Small Claims Court, which does not bring any money for you.
Yes, yes, that's correct, Chief Justice. If you'd like me to address that transformation aspect now, I will.
Yeah, might as well.
Okay. My attitude to transformation has been one of dealing with it at the ground level, getting those basic skills. And the way I identified that quite early in my career, it was about in my 6th year, when I was allocated my first pupil. It was about 24 years ago. When I went through the pupillage period with her name was Bronwyn Wharton, it's just my nature, I just would sit with her, explain things to her, make sure she's properly informed of matters. In other words, not just going through the motions. She's in fact put in a letter of support, Chief Justice, and if I can refer to page 38 of the bundle, I can just read from what she said here because it explains it better than how I can do it. She says, Ashley's approach was inclusive, practical, and engaging. He is a natural mentor. He took pains to ensure I understood the facts, the legal principles, and the rationale behind the litigation approaches taken in his matters. I received patient feedback from him, dispensed in plain English with good humor. Whilst it's not exceptional for members of the bar to have pupils, I know from my long involvement with advocacy training that not all mentors make such a concerted effort to provide a solid foundation for the careers of aspiring colleagues. Now, what happened in my experience there, I realized that if you do this properly, and if you actually make that full effort to bring them and to the level where, and the understanding where you operate, it's a huge springboard for careers. And that's why I went to Janet McCurdy, who is the past chair of the Cape Bar Council, and said to her, I'm more than happy to have more than my fair share of pupils because I think I've got a way to deal with them and to give them that springboard into practice. And they did that for the next 10 to 12 years. Every second year on average, I got a pupil and I did exactly the same thing. The second phase of this comes when I took Silk. Now, when I took Silk, there is the program that Chief Justice you mentioned at the bar with regard to fee sharing and taking second juniors. And AFT acknowledged it, that I participated in that, and they acknowledged that they say, my record is a bit narrow, but they acknowledged that there were concrete activities in this regard. But what they don't, and I appreciate what they've said, what they don't take into account is that what I said, it was mainly in fee sharing and second junior, sorry, not mainly, I said there were many fee sharing arrangements. It wasn't just that. I also encouraged juniors in the transformation spirit to be briefed directly as juniors. I think that's more important. So of those ones that I've listed that I could remember in my submission, quite a few of them are actually direct juniors that were briefed with me. And I took the same attitude that I took when I approached pupillage. And the letter of Gugulethu Samkanga, which is at page 42 of the bundle. I'm quite humbled by what she said here, but in the second paragraph, she said, I've had the privilege of working closely with him, that's me, and my experience has been profoundly formative. He is the only senior with whom I've sat side by side, working off the same computer, drafting affidavits and heads of argument together in real time. We spent hours refining legal arguments, discussing the finer points of authority, and ensuring that every document placed before a court met the highest standards. And the end of the paragraph, one of the most valuable lessons he taught me is the discipline of completing tasks immediately, a principle that continues to shape my own practice. So what I'd done in pupillage, I transferred to, when my practice developed, to having juniors. And there are other examples like that. I won't detain you with references to that. And what I can say, there's a problem with briefing patterns at the bar. There's no question. It's not just the fault of the bar, of course. One of the previous interviewees pointed out that, and I think one of the commissioners, I can't remember who exactly it was, I think made the very good point that I think she used the words, we need to educate the clients, because ultimately the clients decide. And it's a whole joint effort to get this right. And what I've found from what I've done over these past years, obviously it's not all because of me, there's inherent talent, there's hard work, there's other people who've made input. But out of those people, my juniors and my pupils, the vast majority of them are still at the bar. I can tell you that there are a substantial number of them who I've got no doubt, with the passage of time, have got the quality to be silks. Both the letters that I've referred to, from Guguletu Samkanga, Bronwyn Wharton, in fact, I've said to Bronwyn, she's there already, she should be applying for a silk. Guguletu Samkanga, I've got no doubt she'll be a silk one day. Nate Moritz, if he carries on in the legal profession, he has got all the ability to be a silk. So yes, it's been excruciating and painfully slow, but I can identify from the little bit that I've done that there are definitely roots coming out with people and colleagues that will become silks and have quality commercial practices. There's others in the list there that I've put. Eurisha Mahilao, for example. I was very impressed with her. In fact, she appeared before me. Someone who wasn't a junior of mine, so I had no input in dealing with her, is Joanne Moodley. She's appeared in one of the cases, the reported judgments, which are before the JSC. Also outstanding. So, but there is no doubt that the briefing patterns aren't there. That's what I identified for transformation, and I made the effort in that regard. Thank you, Chief Justice.
I see that you are following the proceedings on live stream. It is Commissioner Matolo Dlepu who mentioned to, I think, the candidate who came before you.
Yes,
that,
yes.
It's the practitioner's duty to actually advise their clients that it's not only a certain sector of society that is able
Yes.
to
I thought that was such a profound observation, and I agree with it completely.
You acted for 3 terms in this court. You seek to join permanently.
Yes. At the
2024
time that I
2025?
submitted my papers, that's correct. I might just point out that at page, this is minor, but there's just for the sake of completeness, there's a date error. Let me just get the page for the commission. It's page 17. This paragraph 9.2, the period from the 19th of July to the 31st of August, I did myself a disservice. That should be the 20th of September, 2024. And Chief Justice, I have acted for a further term since this. I acted for the first term of this year.
All right. So you have a year.
Yes, I've had a year of a judicial year of acting.
Yes, that's what I mean. And I see that you sat in all the courts, including criminal court.
Yes, that's correct.
But then you say the only experience you have in the criminal law field is only what you have done in respect of the cases you've adjudicated as an acting judge.
Yes, that's correct.
Do you think you have, this is, as you'll agree, it's a very important component of judicial work.
Yes.
Do you think that you have sufficient experience to be able to execute your functions in that regard efficiently and ably?
The short answer is yes. But of course, the experience needs to grow as I move along. But I think the important answer to the question is this. In my period on the bench, I've had 8 criminal appeals, 4 of which were criminal appeals against conviction or sentence, and 4 of which were bail appeals. I dealt with those comfortably. It was not a problem. They all went smoothly. I authored 7 of the 8 judgments in each of those appeals. Not one of them was taken further in any respect. And the judgments that I authored where I sat with another judge, they all concurred in my judgments without any qualification. The second point that I wish to make is that I've also been allocated a very substantial criminal trial. It's a murder trial. It involves 3 accused, and the trial was running in this last term. We've already sat for 15 days in the trial. There was quite complicated. It was one of those matters where there weren't Section 220 admissions on lots of the aspects. So, for example, the ballistics. And then we've had to deal with all of the ballistic evidence. There was lots of expert evidence in that respect. There was other aspects of expert type evidence as well. There was also an interlocutory application in terms of Section 158 of the Criminal Procedure Act for the purposes of hearing some evidence virtually, which I heard. It wasn't opposed, but of course I had to consider it carefully, and I did grant that. The point I simply wish to make is that despite not having had any recent experience in criminal law, I did have some right at the beginning of my practice, but I think that's not relevant at all because it was a long, long time ago, about 27, 28 years ago. I think the important point is that I was very comfortable in dealing with it all. There were no issues, there were no problems, everything went smoothly. I've also found that on the bench, it is extremely collegial. I think we can give credit there to the judge president. I think that collegiality has been substantially enhanced under her tenure. And it's an open door policy. And wherever there's an aspect that I would like to debate or bounce off someone, they are all open to that. And of course, it would be, I think, arrogant not to take the opportunity to access that expertise. Another aspect of criminal law that has been quite common in the 4 terms that I've been there has been the petitions, Section 309, etc. And, you get those packs and you sit with a second judge. Of course, there's not a hearing, but you need to go through the full record and you need to make a decision on whether to grant leave to appeal. I haven't been able to keep a record of those, but I would say at least 10 of those. And all of those, when I sat with the other judge, invariably they would ask me my view first, which is fair enough. And invariably, we would come to the same decision. The point I wish to make is I was completely comfortable in dealing with that, and everything went smoothly. So that's not to pretend that I know everything about criminal law, but I have studied the Criminal Procedure Act. I don't know every provision, that's 100% for sure. But it's very helpful in guiding one in criminal matters. And of course, one looks at the authorities and the textbooks. I use Du Toit quite often. And I have found that following that approach, there has not been a problem at all. And I think that it was Nodell that said I should be asked, would it impact my role as a judge? I think that's the wording they used.
Yeah.
And I think the short answer is it hasn't impacted my role as a judge. I've been able to deal with all those matters and there's been no problem in dealing with them. Thank you, Chief Justice.
Reassuring. And I have to say, it is quite heartening to hear from an outsider that collegiality has improved in that court under the leadership of the current JP. Kudos to you, Judge President.
Yes, I think that's pretty unanimous in our practice down in Cape Town.
Yeah, that really is most heartening. We know the troubles that have beleaguered that division for many, many years.
Yeah.
You have, of course, written judgments during your acting stints, and I see that 5 of them have been reported.
Yes, that's correct, Chief Justice.
And it is judgments on a wide range of legal issues.
Yes, Chief Justice, there has been. I might just also point out that Nodell, I think we're under the mistaken impression that they mentioned my 5 reported judgments, but they were under the mistaken impression that I only had 2 unreported judgments. Maybe that's because that was the 2 that I specifically put forward.
How many have you written?
Yeah, I've written 36 in total, Chief Justice. That includes, I think, 2 extempore judgments, and it includes, I've had various leave to appeal judgments, but 3 of them I have included in that 36, simply because they were quite substantive. They were like 15 to 20 pages. So if you include those, it's 36. If you exclude them, I think it'll be 32.
That is good output. You list as your quasi-judicial experience, your involvement with the Cape Bar Pro Bono Disciplinary Committee as a member and chair of the governing body of South African College High School.
Yes, that's correct, Chief Justice.
Is that experience, you think, has it stood you in good stead during your time on the bench?
Yes, I think it does. I think what one can also add to that is the small claims court experience.
That would be more like it.
We've mentioned that already. And I think what you can also add to that is arbitrations. I've appeared as the arbitrator. I haven't made a tally, but I have appeared as the arbitrator in a number of arbitrations. And obviously it's not a court, but when it comes to the hearing of evidence and the whole procedure, it's more or less the same. And in fact, when I sit as an arbitrator, I try to encourage the parties to agree that the arbitrator sits as if they sit as a high court judge, applying the evidence as a high court judge would. I think a lot of arbitrations operate in that respect.
Yeah, that is relevant experience, indeed. All right, I'm going to ask JP Mabendla-Popona to put questions to you if she has any.
Thanks, Chief Justice. Is it morning or afternoon? Good morning, Mr. Kento.
Good morning, Judge President.
You have served also as a pro bono acting judge in our court.
Yes, that's correct.
Put up your hand to assist when the court needed help, even during recess.
Yes.
Yes, and you've also picked up an issue while you were doing an automatic review from the magistrate's court, and you came to me. You don't need to tell me the details of it, as the matter might still go forward. And can you just briefly say what made you come to me and draw my attention of some potential constitutional issues in that matter?
Yes. So you don't want me to mention what the issues are?
You can mention the issues, but not your views on it.
Oh, okay. So basically what it was is that So it came as an automatic review, and what had happened is the magistrate had recorded, this was an immigration type matter, and had found that it was an illegal immigrant, and the magistrate had recorded that the magistrate is now bound without anything further, to order the deportation of that illegal immigrant. And there actually was I think it was a full bench judgment in Gauteng that supported that view. And it just struck a chord with me. And so I'm not going to comment on the merits of it at all, but I thought it was an important issue. So I thought I should bring it to your attention in order for you to give directions as to whether anything further should be done in regard to that issue.
Okay.
I don't think I should go further than that.
Yes, we can't go further than that. Like other acting judges who at least are there for a term, you've mentioned that you have been given a criminal trial, and you've made interlocutory rulings. Have you on admissibility of evidence? You don't have to tell me the detail of the case, but just the principles around admissibility of evidence. And
No, I didn't make a ruling on admissibility of evidence.
Okay. But okay, even if you haven't, are you familiar with it? And
Yes, of course.
How do you deal with those?
Okay, you deal with it in a trial within a trial. So it's a self-contained procedure within the trial in the court, and you'll have to reach a result as to whether the contested evidence, so for example, it could be from a contested search and seizure, something like that, or probably the most common one is a confession in terms of Section 217 of the Criminal Procedure Act. You'll have to hear the evidence in respect of whether that is admissible, and then you'd have to make a call as to whether it is admissible. It's best, I think, not to give your reasons there and then for that, because that could color the further conduct of the trial and could result in questions of a leaning one way or the other in the matter, and rather to include the reasons in the final judgment in the matter. If you refuse to admit the evidence, well, then that evidence, you must exercise that judicial fiction of disabusing it from your mind. But I think what that really means at the end of the day is you don't take it into account for the purposes of determining the result of the trial. If you allow it in, well, then it becomes part of the evidence, and then it's also interlocutory, so you can revisit it. If it
a criminal trial can drag on for a long time.
Yes.
And sometimes that has to do with how a judge manages a trial. How do you avoid parties, seeking postponements endlessly, especially when they see an acting judge who's doing a criminal matter for the first time, or who doesn't have experience in it?
Yeah, well, I've got plenty of trial experience, obviously not as a criminal lawyer, but I've got plenty of trial experience as a civil lawyer, and all those tactics are employed in those trials as well. There's a decision of the SCA, I think it's take and save, and it talks about the oldest tricks in the book, like the attorney withdrawing at the last moment and then reappearing once the postponement is granted. There were inklings of that at the beginning of the criminal trial that you allocated it to me, Judge President, but I made it absolutely clear. There's going to have to be very, very valid reasons for this trial not to proceed. It's been coming for a long, long time, and all inklings of that quickly receded, and the trial ran. One thing I have experienced in running the criminal trial is that, and I suppose it's just the nature of the beast, is that often a lot of the hours in the day are not taken up because you finish with a witness and then the next witness is not there, etc., etc. Obviously, you try and encourage that not to happen, but that's something that can happen. In the trial that I've run, we've been the legal practitioners. I've run a tight ship. The legal practitioners have played ball the state advocate, the prosecutor, and the defense counsel. I think they've both been very good in the matter, and the matter's proceeding very smoothly. And we've worked out how long it should take, and we're reconvening on the 18th of...
Sorry, you don't have to tell me about your case. I was just asking generally. Okay.
Yeah, actually, it's just a moment, JP. I forgot to warn you at the outset that we are running on very tight timelines. So if you could just keep your answers as concise as possible.
Thank you, Chief Justice.
One last question, CJ, if I may. It has become a norm for state respondents in review matters, in matters that when an interim interdict is brought against them, to say that it cannot be granted because this is not the clearest of cases. Is the outer principle applicable every time an interdict is brought against the exercise of public power?
Well, it can be, but it's not always. I think that's the problem. So people have read the outer case and they think, ooh, this gives us it becomes a much, much higher hurdle in all interim interdicts, but that's not correct as I understand the law. The clearest of cases, what happened in the outer case, the court held that this was a very, very policy-driven situation. It was very polycentric. The facts were that it was the Gauteng freeway project. There had been billions and billions and billions invested in it. These beautiful roads had been built. They were about to implement the whole program, and then an interdict was sought to stop the project. And the court, I think quite correctly said, well, no, you can't do that. And I think the underlying core principle of the case rests in the separation of powers. And in that circumstance, the court would then be trespassing into the territory of the executive in the terms of the exercising of public power, the polycentric situation. And there the court said, no, then it's going to have to be a very much higher, different standard of the clearest cases. But when it comes to your stock standard administrative decision that doesn't have those type of characteristics, then it's not the clearest of cases, and it would be the normal prima facie case that is required. There were subsequent cases. I think Eskom was one, I think the EFS versus Gordon, and then I actually appeared as counsel in one. It's a matter in our division. It was last year, judgment of Hofmeyer AJ in precision meters, and she explains it quite well, and I was the beneficiary of that result, and I agree with that decision. There's a distinction. It depends.
All right, thank you, CJ.
Thank you, JP. Advocate Boshoff.
Thank you, Chief Justice. Advocate Cantor, hi.
Morning, Advocate Boshoff.
Just a technical question. So, can an organ of state cancel a tender or refuse to contract with a tenderer based on reputational risk posed by such tenderer to the procuring institution? So if an institution, an organ of state, a department or so were to go out to tender and the only bidder or one of the bidders poses significant reputational harm because of serious media reports or issues in the public domain that could potentially cause reputational risk to the procuring institution, can that institution pass them over or cancel the tender?
I must say I don't actually know the actual legal answer to that question, but I think it would be a lot informed by the legislation in question as to the criteria that can be taken into account. But I do not know the actual answer to that.
All right. Yes, because this division actually, not too recently, or quite recently, in a matter of the City of Cape Town against the construction company, confirmed that the inclusion in the supply chain policy of the city that made provision for such cancellations or passing over where there was a material risk for reputational harm. The court confirmed that that was perfectly lawful, and procuring institutions do have a right to reputational integrity, etc.
Well, that makes sense because
Yeah.
you don't want the whole process called into question.
Yes.
So, yeah, my instinct says that makes sense.
Then just on a personal note, I just also want to commend you on, many moons ago, I was a junior at the bar, and I can confirm also, amongst my fellow pupils and juniors, you were always perceived as, not as intimidating as the other senior juniors or whatever, and you were always approachable and were always pleasant to run into you in Kirom Street and so on.
Oh, well, thank you very much. I think that's one of the important hallmarks at the bar.
Any other questions, Commissioners? Commissioner Posoli Retoi?
Thank you, CJ. Good afternoon.
I think I need my binoculars here to see who's talking.
You can use the screen.
Oh, okay.
You can look up on the screen.
I've got it. Thank you.
Good afternoon, Advocate Kantor.
Good afternoon, Commissioner.
Yes. My question is one, are you aware of the anti-sexual harassment policy?
Yes, I am.
Have you acquainted yourself with it?
Yes, I have.
Do you subscribe to it? Would you subscribe to it?
Yes, I would. I agree with it. I've read it quite carefully, and I think it's a quite impressive document. If you'd like me to elaborate, I will.
No, that's fine. We just want to be certain that you are aware of the policy.
Yes.
Thank you. Thank you, CJ.
All right. That brings us to the end of your interview, Advocate Kantor. Thank you very much for making yourself available.
Thank you
for
very
this
much, Chief
vacancy.
Justice, Judge President, and Commissioners.
You're excused.
Thank you.
Advocate Mapoma.
Good afternoon, Chief Justice, and good afternoon, members of the Commission.
I think I should declare that although we are not close and I have not seen you in many years,
Indeed.
I do know you quite well from my hometown, Mthatha.
Indeed, Chief Justice.
How are you?
I'm very well, Chief Justice. And how are you?
I'm fine too.
Thank you.
Are you ready to do this?
We can proceed.
All
Chief
right,
CJ.
let's do that then. You hold a number of academic qualifications. Very proud of you. A BProc from the former University of Transkei, an LLB from the University of the Western Cape,
Correct, CJ.
an advanced diploma in labor law from what was known as RAU,
Yes, yes.
an LLM in corporate law from UNISA,
That's correct, CJ.
and an MBA from UCT.
That's correct, CJ.
You practiced as an attorney between 1995 and 2002.
That's correct, CJ.
From 1996, between 1996 and 2001, you served as a legal officer and leader of evidence in the Truth and Reconciliation Commission, not so?
Yes, that's correct, CJ.
You were in the Amnesty Committee.
Indeed.
And this, understandably, you consider as your real contribution to the justice system of our country, out of everything you've done.
Yes, thanks. Thanks.
You spent a number of years, over a decade, 2002 to 2015, in the executive management of KUHA, the KUHA Development Corporation.
That is correct, CJ.
What did you do there?
Initially, when I was recruited to KUHA, I managed the office of the chief executive, and I was a special advisor to the chief executive, working directly with the legal department, because at the time it was during the conceptual phase of the KUHA project, and there were a lot of legal challenges that it was confronted with, as well as stakeholder management issues that essentially were challenging the very concept of the KUHA project, which was intended to grow the economy of the Eastern Cape by attracting investment into the Eastern Cape and therefore creating jobs and skilling people, and therefore effectively changing the lives of the people.
Then you decided to go to the bar in 2015.
Yes, CJ. There came a stage where, in fact, even when I left attorney's practice, I was clear that there will come a stage where I'll come back to practice law, because one of the challenges at the time when I left the professions was to set up and run effectively a successful practice due to challenges that are largely infrastructure related for you to make a successful practice. So when the time came for me to come back to the profession at the bar, I was well equipped in terms of now the infrastructure, so much so that I had a library that I established, which was a resource for my colleagues, young colleagues in particular, at the bar.
All right. What kind of practice do you run?
It's a largely general CJ, but it had, amongst others, employment law. I was quite a frequent visitor at the labor court, arbitration in the bargaining councils, and then the high court work that entailed general civil work, and to a very limited extent, criminal law. The high court work that I was doing would be more administrative law work, public law work that relates to interdicts and evictions, and many other related work in general, including, of course, the commercial work to a limited extent, I must say, because commercial work in the context of the Western Cape, you could only be involved when you defend somebody who is opposing foreclosures.
Yeah. You have, well, in addition to running a practice, you are, I did pick up somewhere that you are involved in, you have a range of, first you have a range of other certificates, academic certificates, including in the field of ADR mediation. Is it mediation and arbitration?
Sorry, CJ, could you please repeat?
Okay, let me go back to my notes. There is just something I forgot to raise with you. You are an accredited, in addition to the other things you've done over and above what we mentioned earlier.
Yes.
We've completed a range of other executive training programs.
Yes, indeed.
Which include being an accredited mediator and arbitrator.
Indeed, indeed.
All right. Now, you have acted as a judge since 2024, intermittently until...
Yes, CJ, that was my first acting stint in the second term of 2024, and I took the full term. I must say, CJ, that that was preceded by my surgery training, because upon being invited to act, I felt it was imperative of me to attend surgery so that at least I hit the ground running as much as possible.
So that training did help you? Okay. So you acted for a term between March and June 2024, then again for a brief stint, was it a month, 2 months? In January and February.
In January, half a month in January, SCG.
Okay.
I mean, half a term, my apologies.
Half a term.
Yes.
And I'm not sure why you've staggered, but it appears that it was a continuous, you said January to February, then was there recess, or what was the reason for the break? Because you were there in March until June.
I think there was, when I was invited to act in 2024 for the first time, I was encouraged to act for additional terms, but I requested that I be allowed to go back to my practice so that my practice doesn't suffer.
All right.
Then when I came back, then I was given a first term, half a term on the first term of that year.
Then you did the same thing in the third and fourth terms of 2025.
Yes, because actually the CJ, the newly appointed judge president was not impressed that I took half a term because she wanted me to take the full term on the following term. That's how I got them to come back and then act in a more decisive manner, so to speak.
Right. You have also acted in the labor court, but on a pro bono basis.
Indeed, I acted in the labor court. I penned some judgments, but on a pro bono basis.
In the labor court?
Yes.
How many?
I wrote 3 judgments in the labor court because I served only for a week, 5 days.
All right.
Yes, during that period. Incidentally, that was a period that coincided with the end of the term in the High Court. But I had already committed early in January, so I had to honor that. So that's why I took just a week.
Okay, makes sense. You've written judgments in the High Court as well, not so?
Yes, I've written judgments.
How many?
In the High Court, I've written 39 judgments, CJ. Included in the 39 judgments is the criminal court, criminal trial that took 57 weeks. It was a longish criminal trial with a lot of interlocutory challenges from the defense, and that made it drag so that long.
All right. So despite the fact that your practice does not include criminal work, you have had some experience
Yes.
adjudicating criminal cases in the High Court.
Yes, CJ. Actually, when I started the trial, I had, in fact, in the start of my practice, as an attorney, I did largely criminal work in Mthatha. From the time I was the candidate attorney for 2 years until I was a professional assistant, I did a lot of criminal work, so I had a fair exposure to criminal work.
Right. Any of your judgments reported?
I have got 6 judgments reported, but I must say there's only one in the South African law report, and then 5, including the one in the SA law report, are in the Juda online. I'm not counting those that are in SAFLI.
All right. You have had wide involvement in many organizations in the professions and in your communities. But I noticed that you have had close ties with one particular political party.
No, I don't have any
Anymore.
anymore. I
All
was
right.
once involved when I was a student, a young person until 1994. Then post 1994, I never got involved in any political activity.
All right. In the glory days of democracy. So
Yes.
you assure us that you no longer have links with that
Indeed.
political party.
Indeed.
Or
And
any political party, it seems.
I'm not at all. In fact, even during the time I joined the TRC, that was in 1996, I already had severe ties with politics altogether.
All right. Do you have questions for this candidate, JP?
I'm going to try and truncate as much as I can, Chief Justice.
The restrictions don't apply to you because this is your court. It just applies to the rest of us.
Thank you, Chief Justice. Good afternoon, Acting Judge Mapoma.
Good afternoon, JP.
You've acted for 46 weeks in total, including this term. And how have you found your acting stint in our court?
In the High Court.
Yes, in our court, in the High Court.
Oh yes, I found the experience quite revealing, I must say, because one of the important insights that came out of that exercise was that in practice, some of the areas of law that you do not get exposed into applying. But if you get to preside over them, that became the best opportunity to me to exercise my knowledge of law in those areas, and I acquitted myself well in writing those judgments.
Yes,
And amongst other things also, not only now from the hard system in terms of the work, also from the soft systems, I found it welcoming an environment from the judges that welcome there, friendly and also empowering in terms of knowledge sharing. Always ready to assist when you've got questions, always ready to assist when you've got some tricky issues on how to approach them. So it was quite an empowering exercise, I must say.
And you've sat on in appeals with the judges and given input and received input when you sit with them.
Indeed. What also I found also quite encouraging is that these senior judges you sit with will always tell you that you are not an acting judge. You are a judge for all intents and purposes. So make your fullest input without any fear. Even when you disagree, say it your divergent view without any fear, because it can only improve the best results of the trial, of the judgment.
Yes. And as the law bodies commend you, you write solid, well-reasoned, and well-structured judgments. But in the interest of time, I'm not gonna ask on one of your judgments. I wanna just ask a question on perjury and legality.
Yes.
Can you tell us about the difference in the assessment of the delay between perjury and legality? We know perjury is 180 days in which to bring the review application. And so how do you assess delay in legality matters?
If the difference between the two is that PAJA is a statute that gives effect to the provisions of Section 33 of the Constitution. And it is looking at a review of the administrative action. Legality, on the other side, derives its power from the Constitution direct and outside PAJA. It does not, it deals with issues that are not necessarily administrative action, but issues that require review. For instance, based on unlawful action or decision by the wielder of the power.
Like other acting judges, you were given a criminal trial, or I'm not sure if 1 or 2 criminal trials since last year.
So
can you just remind me how many criminal trials you've been allocated since last year?
So could you just repeat?
Can you just remind me how many criminal trials had been allocated to you since last year? Is it 1 or 2?
Oh, it was 1 criminal trial, JP, but as I say, it took long.
It took long.
Because of the interlocutors that were there.
Okay. And you've had an opportunity of doing or making rulings?
Yes.
Interlocutory rulings, and learned from those. And can you perhaps inform us what have you learned from that?
Yes.
And what types of rulings did you get to
Yes,
to make?
the first that required my ruling was a trial within a trial, because there were 3 accused persons. All of them had warning statements that they signed, but they denied or challenged.
You don't need to tell us about your case. I just want to say, don't tell us about the issues in your case, but just generally what you've learned in the criminal trials or trial that you have been conducting.
Thank you, JP. The first was the trial within a trial on how to treat the admissibility of evidence that is being denied by the accused persons. The second stage was when I had to rule on the admissibility of the hearsay evidence in terms of Section 3 of the Law of Evidence Amendment Act, where the statements were warning statements made by the deceased persons, which were implicating the accused persons. Then the third was when one of the accused dismissed, so to speak, his legal representative who was appointed by the legal aid. And now the legal aid refused to appoint another legal representative for that person. I had to conduct an inquiry in terms of the Section 22 of the Legal Aid Act, where I then ultimately made a ruling that the accused person should be provided legal representation because of the seriousness of the charges he was facing and a potential life sentence. So that's one of those that I had to deal with. And then, yes.
Thank you, CJ.
AP Advocate Boshoff.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon, Advocate Boshoff.
You would have noted in the bundle there was a comment raised by an attorney regarding leave to appeal judgment you wrote in a matter of Pinar v. Coens.
Yes.
And it had to do with the amendment of particulars of claim, where they sought to introduce a new cause of action into the particulars of claim.
Yes.
Now, I had a look at your judgment, and you correctly cite the matter of Rustenburg Mines as the authority for kind of determining whether or not, because at the heart of the issue was when prescription would have started to run in terms of this new cause of action, and whether by reason of that it should be disallowed, the amendment. And the court in the SCA in the Rustenburg Mines case, you correctly state that that the material facts which must be proved for the plaintiff to succeed, sought to be introduced by the amendment, gives rise to a different right of action or debt to the originally claimed. That plaintiff will be precluded from effecting the amendment if the relevant prescriptive period has run.
Yes.
So that's correct. But in paragraph 12 of your judgment, you then state that it seems you take the emphasis away from the question of whether or not a new debt has arisen, and you place the emphasis on the cause of action. And the matter of Rustenburg Mines, the SCA went to great lengths to distinguish the two concepts, to say that not all causes of action would necessarily give rise to a new debt in terms of the Prescription Act.
Yes.
So the criticism is, and my submission is that it's fairly raised, is that whilst you correctly cite the Rustenburg Mines case in the test, you applied incorrectly by then reverting back to a focus on the fact that whereas the initial claim arose from the Consumer Protection Act, this new claim arose from a different cause of action, and therefore you calculated prescription based on the facts underlying that cause of action, rather than considering whether a new claim as such has arisen. Now, we don't have to debate the law. I think it's just, the question is more, I suppose the criticism that is raised is that you're perhaps then not suited for elevation to the bench, given your interaction with the law in this matter. And I would just like to give you an opportunity to comment and speak to the issue. And yeah.
Thank you. Thank you very much, Advocate Bosho. I must start by saying that as a matter of principle, a feedback, whether positive or negative, I can only improve from it. That's as a matter of principle. So once I saw that letter, I took time to go back to look at both the judgment because I wrote both judgments. I first wrote the judgment where I refused the amendment of particulars of claim. And then when I refused leave to appeal, I also penned the judgment. The one that the objectors, the adverse commenters are touching is a judgment on the leave to appeal. So when I looked at it, I couldn't agree with the people that were objecting that for that reason. What also complicated matters in how that letter is couched is really concerning. Firstly, the person says that I might be busy with other businesses of mine and other commitments, and therefore I'm not even known by my colleagues in the bar, and therefore I should not understand civil procedure. That was an unfortunate opening statement because, as a matter of fact, and I think I must say this, I do not have any other business. I live entirely on my practice. And secondly, I do not believe that simply because I'm not known, therefore I'm incompetent. And by the way, I am a leader of a certain colleagues in the profession. There are people who know me. I know and I accept that in fairness, not everybody should know. But I humbly say that it cannot be that because I'm not known, therefore, somebody can just assume that I don't know civil procedure. I did my level best to apply the law to the facts and made my judgments. And I also asked the registrar to help look as to whether there was a petition against this judgment. And there was none. Ordinarily, if an objection comes from a legal practitioner as seasoned as the person who was objecting, one would have expected that if she feels so strongly about a different view from how I found, at least one would ask for petition so that the law can be clarified on the issue. But from where I sit, advocate, my humble view is that I did what should be done and my judgment is correct. Thank you.
Thank you, CJ.
Thank you, Advocate Boshoff. JP Tlaleitse.
Thank you, CJ. Good day, Mr. Mapoma. Here am I. Yeah.
Good
In
day,
2020, you said in a matter in Makhanda, Mabete, Tilana Incorporated versus Bason and others. I don't know if you still remember that matter.
I must correct that, and I must apologize, CJ and commissioners, not to have made that point very clear from the start. I never acted in the Eastern Cape. There is Advocate Mapoma, SC, who practices in the Eastern Cape and Gauteng. He is the one who was acting there. So that judgment does not relate to me.
Because I see it's ascribed to you in your papers by one of the bodies, Advocates for Transformation. And they were showering you with praises on the judgment. Thank you, CJ.
Hi, good afternoon.
Good afternoon, Commissioner.
It's just a follow-up question on the debate that we have been having with Advocate Boshoff regarding the comments, the adverse or the objection of adverse comments that were made by the Trudy Brookman attorneys. Incidentally, there were the attorneys of record in the matter that you, in the application for leave to appeal that you dismissed, in the matter of Anthony
Sorry, Commissioner, I'm struggling to hear.
Oh, sorry. My question is a sort of a follow-up on the debate that we have been having with Advocate Boshoff regarding the comments that was raised by Trudy Brookman attorneys.
Yes.
And in which they criticize your application of is a judgment of Rustenburg Mines Industrial in.
Yes.
And they said that you incorrectly applied the principle as set out in that judgment.
Yes.
So my question to you is that through the Brookman attorneys, incidentally, are the attorneys for the applicant in the matter of Anthony Pinar. That is the matter relating to the application for leave to appeal, which you dismissed, and they were acting for the applicant in that application for leave to appeal. Is that correct?
Yes, they were.
Okay, that's what I wanted to clarify. That maybe that is the context in which the objection or the comment should be made. Thank you.
Thank you.
Should be understood. Sorry.
If I may just explain, Commissioner, yes, they were acting for the applicant in the application to amend, but with a different counsel. And then when they applied for leave to appeal, another counsel came. That's otherwise, as instructing attorneys, they were acting for both, in both instances.
Okay, thank you. I've answered my question. Thank you, CJ.
Thank you, DP Minister.
Thank you very much, CJ. Good morning, Advocate Mayos.
Good afternoon, Minister.
Good afternoon. Oh, yeah. My apologies. It's been a long week. I just looked at the area where you are reflecting your work in terms of Cricket South Africa and the Tutu Intellectual Property Trust. And you do indicate that if appointed at the bench, you'll either resign or continue to serve, only with the proviso that I will not accept any payment for my services. Maybe if you can clarify that.
Could I ask Minister to just direct me?
It's on your questionnaire,
Yes.
page 28A. It's written that way. Number under 15. So it's 14 and 15, they follow each other. So on 15, you are requested to list all directorships you hold and other interests in businesses. So you listed those three. You said you've got no business interest in the past 10 years, but you've listed the Cricket South Africa and Tutu Intellectual Property Trust. And then on 15, then the question asks you, what would you do if you are appointed on the bench? And you do indicate that your term in Cricket South Africa ends September 2026. Am I assuming when you say you continue to work, is it on the Tutu Intellectual Property Trust? Or maybe just clarify that part.
I'm sorry,
I think you're referring
I
to
need some
another
assistance
candidate,
to
Minister.
follow.
That sounds like
I've got it.
Mayos's CV.
Mine, it says Mayos. This is the pack I've got from the secretariat. That's why I was
Unless
correct.
I'm the one who's confused.
Let me just check. Maybe let's pause and check it.
Which part?
This is my former.
Maybe I use.
It's the next one. I can see you really rushed.
I'll come back. I rushed to the next one. My apologies for that.
No, don't worry about it.
Pack it. I even greeted you as Mayos, actually. I did.
The same.
So I was asking the right question to them, but not to them.
All right. You don't need to look. You don't need to rifle through your papers any longer. It's been cleared up.
Oh, okay. Thank you. Thank you.
Have you found your bearings, Minister? Or you don't want to put questions to this candidate? Okay. All right. Commissioner Matolo.
Thank you, CJ. Good afternoon, Advocate Mapom.
Good afternoon, Commissioner.
I have to declare that I know you in the BLA. We have been together trying to mentor young practitioners, and it will be sad for me to lose you, actually. But what I wanted to find out from you, we normally talk about briefing patterns at the Cape Bar. I just want to hear you, because you are on the other side, you are a black practitioner.
Yeah.
How do you find the briefing patterns at the Cape Bar?
How do I?
How do you find, are they fair? I mean, how do you get briefs from good briefs that you are supposed to be getting, because you are very senior? Thanks.
It's not an easy environment, I must say, because amongst other things, and most importantly, access to work is always a problem. If you practice in the Western Cape Bar and you are black, particularly African, if the state attorney doesn't come to your rescue in terms of instructions, you might as well close. Because the private sector is not ready, I must say, at this stage, to brief Black Council. So it's one of the challenges. But I must say, though, that in the tenure I've been in the Cape Bar, I've seen, it's only fair to say, I've seen some positives in terms of programs that seek to be responding, but I think there's still a lot that can be done. More in particular from the state attorney's office, because I think there is better management that can be offered there in terms of the procurement of council. There's still a gap there. But a lot needs to be done, especially from those that are senior, because in the Cape Bar, if we are not known, it's not easy to navigate through. I survived personally because I came back to practice ready in terms of experience, in terms of the support infrastructure, so I was able to stand on my own, but I'm an exception. That's why I took it upon myself as much as possible to assist the young ones as much as possible whenever I find opportunity to do so.
Yes, Chief Justice.
Thank you, Mr. Mkhwanazi. I'm a CJ for the time being. Okay.
Thank you, Acting CJ. Afternoon, Council Mapoma.
Afternoon, Commissioner Mkhwanazi.
If I may also start declaring that Acting CJ, I know the candidate before you, not from anything outside the professional organization, to which we only meet at the times arranged, but nothing beyond that. He's based in the Western Cape, I'm based in Gauteng. Advocate Mapoma, I want you to cast your eye on the importance of involvement of practitioners in the professional bodies. If you look at the composition of all these divisions and who heads them, you would see that from the Concord up to lower divisions, most, if not all, cut their teeth in the professional organizations. Now, I want you to look at it insofar as it relates to you, how your involvement, including the leadership that you got the benefit to take, shaped you and made you ready perhaps to be an available candidate. Thank you.
Yes, my involvement in the legal formations has been helpful from the point of view of knowing your colleagues to start with. Because if you don't know your colleagues and you will run out of support system. And also not only that, being conscious of what needs to be done to change the landscape so far as advancement of Black practitioners is concerned in the Western Cape, and to put your shoulder on the wheel and do what you could do. So the organizations, both AFT and the PLA, have helped me to give me opportunity to assist, especially the young and struggling networks, with support and also with instilling in their minds that without competence, you will not be able to make a mark in the profession. And transformation, for it to take place effectively, competence must be mastered by our members. So that principle has worked a lot, and it's a principle that I've always instilled.
Thank you, Commissioner Mkhwanazi. Commissioner Posoli Rotolo.
Good afternoon, Advocate Mapoma.
Good afternoon, Commissioner.
It has become very difficult now to have analyzed the review of your judgments, because now you say that some of the judgments were not written by you, but by one Mapoma SC.
Not some, Commissioner, one. The one in the Eastern Cape that was done in 2020, way before I took acting appointment.
Okay. So the pro Kaya construction versus City of Cape Town, that one is yours,
Yes, yes.
as well as where you were enforcing a JBCC adjudicator's determination of approximately 8 million. That one is yours.
All the judgments, Commissioner, that I have attached in my
The
application
ones you have attached.
are judgments that were penned by me in the Western Cape Division.
Well, it looks like AFT goes beyond what you have attached. They search the web for any judgments in your name, because they want, the understanding is that, of course, you'd attach the best. And the idea is to get a more rounded view of your judgment writing. That's really the objective. So we see the ones you have attached, but AFT would go beyond that.
Yes,
Yes.
yes.
But anyway, they are happy with your judgments. They have said you have made sound, well-reasoned judgments, and in AFT's view, you have solid transformation credentials as well as a leader in most, which is a rare attribute of having held a leadership position in most of the progressive professional organizations. Be that as it may, I need to assure that you are acquainted with the anti-sexual harassment policy.
Yes, indeed. I have actually, this policy was shared in the division, and with all of us as judges, acting and permanent judges, and I'm fairly acquainted with it.
You believe that it is implementable in its current form?
I believe it is, Commissioner. In fact, it's a long overdue policy, because the policy by its nature is an instrument that helps people against themselves and protects people against themselves. So it always helps when there is a policy framework that is in place to guide the conduct generally of people, and most particularly in this case of the judges, because the behavioral issues that relate to judges are of paramount importance to the confidence that the public should have. So if there are instruments like this that protect the judges from crossing the line, it can only help. So I'm happy with it as it is. I commend it, actually.
Thank you. Thank you, CJ.
Thank you, Commissioner Posen. Thank you very much, Advocate Mapoma.
Thank you, CJ.
And for your patience, we were supposed to interview you yesterday, not so?
Yes, yes.
Yeah, we do appreciate
Thank
your
you so
patience
much.
with us. You're excused.
Good afternoon, Chief Justice.
How are you, ma'am?
Stressed, but fine, thank you.
I'm just looking at your application papers, and I don't mean this as criticism, I'm just poking fun at you. In my entire time as a member of this board, I've not seen one this thick. So you owe us big. You took a lot of our time because we had to go through all of this. But as I said, I'm not criticizing you in any manner. It just shows that you are a perfectionist. I suspect you are a perfectionist, and I hope this does not mean that you will write long judgments if we appoint you as a judge. Well, we recommend your appointment as a judge.
I don't know, CJ, coming from the Constitutional Court, I don't think you can say that.
Touché. All right. Where do we start? You have a long CV. Let me just go back. You did BProc and LLB degrees, excuse me, at the University of Cape Town, right?
No, Chief Justice, at the University of Natal, Durban campus.
At my alma mater, what we used to call Howard College.
Howard College.
Yes. Then you got a scholarship to do an LLM at the University College in London.
That's right, Chief Justice.
Which you passed with merit.
Yes, Chief Justice.
Okay. You did articles, was a professional assistant for a year, then took up a position as a tutor at the University of Cape Town. And you say that is when you were waiting to go overseas for your LLM.
Yes, that's right, Chief Justice.
Then in 1999 to 1992, you were lecturing at the University of Cape Town.
Yes, till 2002.
Yes. Which subjects did you teach there?
Insolvency, company law, business law, and I had a short stint teaching master's students international trade law.
Right. Then you left and went to Port Elizabeth to join the Kucha Development Corporation. And
Yes,
I see that you assumed a number of roles in that organization. Can you tell us briefly what you did there in the 4 years you were
Yes.
there?
So I was the procurement manager, the legal advisor, and at some point I took up the role of, in addition to those two, being the company's secretary.
Mm-hmm. And that was until, you were there until 2006?
Yes, Chief Justice, until 2006 when I decided to go to the bar.
Uh-huh. And you did your pupillage at the Cape Bar where you are still practicing?
That's right, Chief Justice.
What kind of practice did you run? I understand that you gave up your practice last year, well, in 2000, at the end of 2004, and decided to make yourself available for acting judicial appointment.
Yes, so my practice consisted mainly of constitutional law, administrative law, some family law. I came upon an area of law I didn't even know existed in the area of Hague Convention applications. So I did a lot of that. I'm trying to get to the place in my questionnaire where shipping law seems to have crept in. I must correct that. It must have been wishful thinking on my part. I've never done shipping law in my life.
All right, thanks for that correction. No criminal work?
No, not in my practice.
Okay. And then you say you decided to close shop and make yourself available for acting judicial appointment.
Yes, that's right.
By all appearances, you're running a busy practice. May I ask what brought on that radical decision? To say you actually gave up your practice is something else. I suppose you'll go back if you don't succeed today.
Yes, I will go back
Okay,
and
so
start it from scratch.
Okay, that's the plan.
Yes, but
All right.
I came to a point where I had to decide whether or not to take silk, or whether to really do something with my life that I would be proud of. And I had acted before whilst I was also practicing, and it's very, very disruptive. So I decided that in order to do justice to the acting stint and my acting, I wanted to give my attention to it and see how that panned out, because I had the sense that being at the bench would be where I would serve best. So that's why I took that decision.
How have you found the experience? Were your senses right?
Yes, it's very, very meaningful work, very hard, difficult work, but very important and meaningful work.
So it has been a year and a term. You've been there.
Yes, it's been a year last year I acted for the whole year. In the first term of this year, I acted from February until the end of the term. And then I'm still acting now. But before that, I had acted for half a term in 2015, half a term in 2020, in 2023 for 2 full terms, 2024 half a term.
All right.
So I think in total, when I estimate, it's about 68 weeks.
That's a long time. That would have given you an opportunity to sit in all the courts in that division, not so?
Yes, that's right. I did sit in all the courts, criminal and civil.
And you have run criminal trials?
Yes, I've run criminal trials. Both of them are still running. They're at different stages. One is at sentencing stage. We're awaiting the probation officer's reports. And the other one, in fact, I gave out my verdict and my sentence recently.
How many judgments have you written?
I haven't counted the extempores. I haven't counted the leave to appeals that I've written. So excluding those, I would estimate between 50 and 55.
Have any of them been reported?
Yes, 5 that I was able to find.
All right. I'm not going to ask you any further questions for now, and will instead hand over to JP Mabintla Bokwana to see if she wants to explore anything with you. JP?
Thank you, Chief Justice. Good afternoon, Acting Judge Mayosi.
Good afternoon, JP.
How are you?
I'm well, thank you. How are you, JP?
Very well, thank you. You've acted for 83 weeks in the division. And how have you found your acting stint? How have you found the environment in the division?
The environment is very collegial, very supportive. I think all the permanent judges I've interacted with, I've worked with, I've been in matters with, and those I interact with outside of court have been very supportive of me. I have had the distinct feeling that everybody operates on an open door policy. And I've been very supported, in particular with my criminal matters, because before I didn't have criminal law experience. The female judges are particularly supportive of other females. And I find the environment is such that we are very collegial towards each other. It's amongst the acting judges, the acting female judges in particular, it's like a sisterhood. together. We don't compete with each other. We all want the other one to succeed. And I think we're able to interact like that because the environment is conducive. The
Yes.
environment is positive.
I've noticed the sisterhood. You've appeared in court, in all our courts, high courts, Supreme Court of Appeal, Constitutional Court, in very complex matters and landmark cases, and you've had extensive experience in admin law, constitutional law, and a number of cases that you did contributed to the interpretation of various provisions of the law. And some highlighted areas of social justice and protection of rights, and you've been involved in the Khayelitsha Commission and the case that paved the way for that commission. Can you tell us a little bit more about that?
Yes. I think it was about 2013, the Social Justice Coalition was very much involved with the community of Khayelitsha. And by the time they came to us, the legal team, to brief us, they had amassed a dossier of complaints from the community of Khayelitsha. And their complaint was that there was a complete breakdown between them and the police. The police were totally inefficient. And the scale of the problem was such that it warranted a commission of inquiry. So that's how that work came onto our laps. So it was a social justice coalition and other social movements. So our work in the commission of inquiry, we were representing the community of Khayelitsha. So it was very tough because the stories were heartbreaking. And we were giving a voice to the voiceless, which was a big privilege to be able to do. And the conclusion of the inquiry was ultimately that there was a breakdown.
And there was a case that was brought to the Equality Court by Social
Yes.
Justice, and you were the junior in that matter.
Yes,
And,
yes.
and can you tell us the intricacies of that case as well as the outcome that came about with the applicant bringing such a case in the court?
Yes, so that case followed the recommendations of the Khayelitsha Commission of Inquiry. One of the findings was that the manner in which SAPS allocated resources was unequal. They allocated the least resources to Black and poor areas and allocated the most and best resources to white areas. And the problem lay in their system of resource allocation. So the case that was then brought was to force SAPS to implement the recommendations of the Khayelitsha Commission of Inquiry and to change the police resourcing mechanism in order to align with the needs of the poor communities. So the system produced a perverse result in the sense that those who needed the support the least got the most and the best support, and those who needed the SAPS's attention the most got the worst and the least. So the case really was about remedy. What was the appropriate remedy in order to see to it that the recommendations were implemented, and the finding of the court was...
Okay. You don't need to tell us about the remedy at this stage. I think maybe you can tell us about the first part of the case.
The first part, JP?
Yeah, the first part of the case, the finding of unfair discrimination.
Yes, unfair discrimination in the allocation of police resources. I think the court found, as the applicants went to court to assert, that there was in fact a discriminatory, the manner in which SAPS allocated resources was discriminatory.
Okay. A senior colleague has commended you for your preparation in court in a matter, I think that you've attached here. You sat in the full court, And you would recall that some of you had to be asked specifically to postpone some of your matters because of that particular matter, because the court or we required to constitute a full court at the time. And that colleague said that council relied on a provision in the Act, and you asked council to read further. And actually that reading further ended up being a point that was dispositive of the appeal. Do you recall that case?
Yes, I do, JP.
Okay, what was the issue there? Or maybe just briefly, you don't have to go
The issue,
to detail.
okay. I think it was the fuel levy. The applicant came to court on an extremely urgent basis. They came to court to interdict the minister from implementing the fuel levy. They asserted that.
Again, you don't have to tell the full
Yes,
story.
so that's
because
what
there's
it's
Part
about.
B. But maybe I should just not ask any further in this, in case you get involved in the merits of it. In some of your judgments, you've dealt with the granting of an interim interdict and the requirements applicable thereto. And in one of your judgments, you've held that it is insufficient to rely on the constitutional right to administrative action. One must demonstrate a prima facie right threatened by the impeding harm. Can you explain further on that?
Yes. So the Section 33 right to fair, reasonable, lawful administrative action results in all of us. It is not sufficient to go to court and assert that right. That right has been given effect to, of course, by PAJA, but what you must do in order to succeed in your interim interdict is to show a prima facie right, which, if the interdict is not granted, is going to be harmed, and the Section 33 review right is not sufficient.
Okay, I'm just going to ask one more question, CJ. Can you tell us more about the assessment of the delay in legality reviews? The difference between assessing delays in PAJA and legality, and how do you assess delays in legality reviews?
Legality reviews, you assess delays by looking at the reasons for the delay, the prejudice for the delay, and I'm assuming, JP, you mean for the purposes of condoning the delay?
Yes.
Yes, in terms of Section 9. You look at the extent of the delay, the reasons for the delay, the prejudice caused by the delay, and whether it's in the interests of justice to condone the delay.
Taking into account that PAJA has a period of 180, whereas in legality, you don't have a period, how do you assess?
Reasonableness.
Yes.
Reasonableness, and that's a fact-specific inquiry.
All right, thank you. Thank you, CJ.
Advocate Boshoff.
Thank you, CJ. Advocate Moyosi.
Hello.
I just want to confirm for the record that it was certainly no small thing to give up a practice, because from personal experience, you were so busy we couldn't brief you anymore. Your diary was always full, to our disappointment. So it was certainly no small thing to have done that in service of what you're currently doing. Just a quick technical question. Can you please explain your understanding of the functus officio principle and explain whether this principle establishes an absolute rule or are there exceptions to it?
Once a decision maker has, an administrator or decision maker has made a decision, they are functus officio. And once they have communicated that decision to the third party that it affects, they are functus. In order, and that decision has effect from then on. In order for the decision not to be implemented, the party that seeks to have that decision not implemented must go to court and have that decision set aside. So in other words, if there are problems underlying that decision, the administrator, and I think this was the Curland issue, the administrator cannot willy-nilly decide, well, we're not implementing this because of an illegality inside. It has effect and may have consequences unless set aside by a court.
Yes, so review and self-review and, judicial review in general is one of the kind of structured or popular exceptions to that rule. Are you aware of any other exceptions that would not necessarily require judicial review?
No, I'm not aware of any others at this stage, Commissioner.
All right, that's fine. Thank you, CJ.
Thank you, Advocate. Any questions, Commissioners? No. It appears that we've reached no. I didn't see a hand. I was looking around.
It's the one I wanted to ask.
Indeed. No, this is candidate Mayos.
Good afternoon, Advocate Mayos. They're
Good
laughing at
afternoon,
me
Minister.
because I called somebody else your name. You'd probably have picked up.
I was watching you.
You are
Minister.
watching me. Eh? Yeah. Sorry about that. You now know what I wanted to check. Your
Yes,
area, your
I was
work.
very grateful that I could see beforehand what you wanted to ask.
And you could even prepare your thoughts just around that, because I do know that work is quite important, especially in the cricket, but just indicate how you intend to deal with that, because I was a bit confused when you say you can remain doing the work without income. Have you checked that would be allowed and all those things?
Yes. So I think the rules, the code of conduct says that judges are not allowed to receive any other remuneration. I think there may be instances where the minister may permit it and the JP may permit it. And that is how I intend to deal with, in particular, the CSA involvement, because that is, there are board fees involved. I know without a doubt that's irreconcilable. Those board fees are irreconcilable with my role as a judge, and I have no intention of continuing to receive those board fees if I am appointed. I think the reality of it, I think about this all the time. Should I stay on and find a charity to whom the fees would go, which I think would be, a way to extend my community involvement, or should I just simplify my life and not continue on the board? Today I'm leaning, because I'm faced with all of you, I'm leaning towards the latter. But I will certainly not receive any remuneration from cricket if I'm elevated.
No, thanks, CJ, but it is something that you'll have to think about should you be appointed. I think it's something you must process as we're flagging it. Thanks.
Thank you, Minister.
Well, in light of the extent of poverty in this country, I would not mind it at all if you remained on the board with the relevant permissions, of course, and gave that money to a deserving charity. There is a huge need wherever you look in this country of ours. So don't be so hasty because you are you are pressured by our stares to give that up. Commissioner Steinberg?
No, it's fine, thank you.
Then Commissioner Foster, literally.
Thank you. Thank you, CJ. Good afternoon, Ms. Mayosi.
Good afternoon, Commissioner.
I know you. We know each other from eons ago at the Cape Bar.
Yes.
Yes. There is no doubt that your track record at the bar your practice and everything is stellar. However,
Thank you, Commissioner.
however, the concern from Advocates for Transformation is that you are very thin on transformation matters. What do you say to that?
Thank
the
you.
complaint, really, let me just finish, is that you lack commitment to transformation. There's no organizational membership relating to the transformation organization, and the role you played in the LPC. Perhaps let me leave that out. But yeah, let's just leave it at that.
Thank you, Commissioner. So from the AFT comment, there is a comment that I was a member of AFT for a very short time, and therefore there is a concern about my commitment to transformation. Before I answer that question in relation specifically to my contributions towards transformation, I think I would have benefited from a more detailed, more objective sort of comment, because being a member of AFT is not the only indicator of one's transformation credentials. So as a member of the Cape Bar, I have on many, many occasions, and I can think, leading up to this interview, I can think of at least 9 instances where I involved juniors, even though I'm not a silk, but my practice and the work I was attracting was of such a nature that I could involve juniors if client and the instructing attorney agreed. All the juniors in those 9 instances have been either Black or female or both. I have had a pupil, and in one of the instances where I had a junior, I took that junior with me to the Constitutional Court in a matter that I argued there successfully. Beyond that, organizationally, as a member of the Cape Bar Council, or as a member of the Cape Bar, first of all, I was a member of the pupillage committee. The Cape Bar's pupillage selection policy prioritizes Black females, prioritizes the disabled, and I was a very active member of the pupillage committee and providing support to pupils outside, informally, mentorship outside of the formal work of the pupillage committee. I was a member of the advocacy training committee and dedicated time, including on weekends, to run moot courts in order to train pupils. But I don't think one's transformation credentials should really be limited only to the professional space. Transformation is a question that we must engage in our lives as well, in our communities. And I think in my community, I have sought to influence in a transformed way. I've sought to live transformation in the areas, in my spheres of influence. For example, during the course of the Collegiality Commission, there was a young man who gave evidence there, whose story was so touching. A young man, unemployed, had matriculated, and I paid for his first year of university because he was so smart, he just didn't have resources. Of course, when you do these things, you don't think you're going to have to boast about them when you're applying for the bench. So there's a lot of these things that you do in your private space that you don't file. My involvement with the Indoni Dance and Cultural Initiative is also one of those, where I mentored young women from Khayelitsha in the context of that organization, mentored them financially, mentored them in terms of life skills, just to engage with them and understand their problems and seek to unblock where you can, but also to give them an idea, an image, hopefully through me, of the possibilities for a Black African female. And I think that was also very important work for me. So, yes, Commissioner, I think I can never say I've done enough. I mean, the degree of our problems is such that no one person can ever say they've done enough for transformation, but I have certainly made my efforts in that regard.
Sorry, can I follow-up question?
Yes,
today?
JP.
I was just going to ask Acting Judge Mayosi, as an African woman in the Cape Bar, how was the environment over the years for you?
It was tough. I think if you're an African, generally, an African woman particularly, you must go to the Cape. I would recommend you going to the Cape Bar when you have life experience from other spaces and you have already developed a thick skin. You must go to the Cape Bar with the realization that the world doesn't owe you a living, because you are certainly on your own, Black woman, as it were. So, but I was fortunate in some respects because of prior relationships with attorneys and the mentor that I had at the time. And really, the combination of those two things is a large part of how I got to get into the briefs that I got into. But I mean, it's difficult. You are invisible. You don't have a voice. You have to shout very loud not in the literal sense, in order to be seen. You get involved in briefs where you realize you're just here because you're Black. Otherwise, you're shut out of this brief and you have to cope with that. So in many instances, racism was now, it's no longer overt. These microaggressions, these unsaid things that are very loud. And every African female, every African female has a double whammy. You deal with those every day. And so even though you are seen as being very successful, you are dealing with all of that every day.
I think you've answered the second part of my follow-up question on that I was going to ask, how did you manage to navigate and survive when everyone or other people they were living because of the environment, and how did you get to survive being one of the few there?
Yes, in the early days, because of the relationships that I mentioned, that's how I really managed to break into the work that I broke into. My mentor, the nature of the work she did, and the instructing attorney that we had been using at Gucha was based in Cape Town. And I got to get a lot of work through her. And then the state attorney noticed me, and then I got a lot of work from the state attorney. So I was very fortunate, really, at the beginning. Otherwise, I mean, I could have had the same fate of being unseen. Unfortunately, the belief that merit and transformation cannot resort in the same place still exists. So that's a challenge.
Is the follow-up? We were still in the middle of a commissioner asking questions, so I don't know what to do now. Is the follow-up? Oh, okay.
Sorry, Advocate. Just for interest's sake, who was your mentor?
Fiona Stewart. Oh, sorry. The attorney was Fiona Stewart. My mentor was Nazreen Bauer.
Okay, all right, thank you.
Back to you, Commissioner Poso.
Thank you. Thank you, Ms. Mayosi. We all know and are aware of the hostile environment that is the Cape Bar. I'll now move on to the next question, which no doubt you know now if you are watching the proceedings. Are you aware of the anti-sexual harassment policy?
Yes, I am, Commissioner.
Have you acquainted yourself with it?
Yes, I have. In my view, it's long overdue.
Are you happy with it in its current form?
I am.
Thank you, Chief Justice.
Commissioner Shiban?
Thank you, Chief Justice. Advocate Mayosi, you would have seen the Law Society of South Africa made mention of the complaint or an objection to your candidacy, which is, I noticed, is extremely old and dates back to the Law Society days. There was a complaint lodged against you by Paul Manjanja. Was that resolved? Because we don't seem to, I ask because it's a very old complaint. Could you comment on that?
Yes, so I submitted all the documents relating to that complaint to the Commission. The complaint was resolved at the level of the Cape Bar, where it was not upheld. The gentleman then appealed to the GCB, and the GCB dismissed it for reasons that there were no prospects of success. So that's how it was resolved then.
Thank you.
Anyone else, commissioners? Is there a hand, Commissioner Shirley? Oh, okay. We have reached the end of your interview, Advocate Mayosi, Acting Judge Mayosi. Thank you very much for making yourself available for this, for the sacrifice you made by giving up a lucrative practice, even if it may be temporary. We don't know what's going to happen going forward. And thank you for your patience with us. Should have interviewed you a while back already. Wish you all the best. You're excused.
Thank you, CJ. Thank you, Commissioners.
How are
Good
you?
afternoon, commissioners. I'm
Are
fine.
you well?
I'm fine, thank you.
All right. Apologies for keeping you waiting. You hold an LLB degree from the University of the Western Cape.
That is correct, Chief Justice.
Okay. You started your legal career at the sidebar. You did your articles in 2006, completed them 2008, and was a director at Sharon Williams Attorneys
That is correct.
law firm until 2011. Was that your own practice?
Yeah, it was my own practice.
Okay. So in 2011, you started acting as a magistrate until your permanent appointment as an additional magistrate in 2015.
That is correct.
Mhm. And during your tenure as a magistrate, you have also acted as a regional court magistrate. That was for a year?
That is correct.
Why have you not taken up permanent appointment as a regional magistrate? The opportunity has not come.
I have applied for a permanent post and I was shortlisted for the post. I don't know if it is maybe the demographics that they wanted somebody in that post that was maybe not black but Indian, because an Indian person was appointed for the post that I applied for.
All right. You have acted as a judge of the High Court since you started in April 2024, and according to your questionnaire, your last acting stint was in August 2025.
That is correct.
All right. Have you gone back to your regular job?
Yeah, I've gone back to my court in Wynberg.
All right. In which courts did you sit when you were at the High Court?
I sat in all the courts except tax and shipping matters.
Wait, I'm just trying to total up the times you've listed here, your stints. How long in all did you act?
I acted 38 weeks.
38 weeks. All right. So you sat in all the courts except shipping and tax courts, you say? Okay. And you wrote judgments?
Yes, I wrote judgments.
How many?
When I counted, I had plus minus 80, but I think I've got more than 80 judgments. I did not include the extempores and some of my leave to appeals that I've written judgments on.
Have you written judgments as a magistrate?
Yes, Chief Justice.
Considered judgments that that could be reported, I mean?
I've written judgments in the regional court. I've written judgments in the district court. I've written both criminal and civil judgments in both courts.
Well, you are in the district court, so you sit in both criminal and civil courts.
That is correct, Chief Justice.
And you did the same at the High Court.
That is correct.
Okay. You have long involvement with the Women Judges Association, the SACA IWJ. I know you from there. Well, when you were a practitioner, I imagine that's when you were a member of the BLA.
That is correct, Chief Justice.
But as a judicial officer, you've been a member of SACA IWJ and JOWASA.
That is correct.
And you are currently in the executive committee of JOWASA.
I'm just an additional member on the executive committee.
All right. All right, I'm going to stop there and give JP Mabintle Pokone an opportunity to raise whatever issues she may wish to explore with you.
Thank you, CJ. Good afternoon, Ms. Mthatha.
Good afternoon, JP.
How are you?
I'm fine, thank you.
Good, thank you. First, I just want to also mention you also were part of the Bridget Mabandla aspirant women judges.
That is correct, JP. In 2023, I was part of the Bridget Mabandla Aspirant Women Judges Training, which was for a year.
And how did you find that experience?
The experience was beneficial. I must commend the program. Without that program, I would not have been able to hit the floor running when I started acting in the Western Cape. We were trained extensively on all the procedures of High Court procedures. Different judges from different high courts, Constitutional Court, Labor Court, and it was a very interesting course.
And you were mentored by some of the judges in our court?
Yes, I was mentored by Judge Bartman, who's now in the Supreme Court of Appeal, by Judge Savage, who's now in the Constitutional Court, and by Judge Henny, Judge Vele, various judges in the Western Cape High Court.
And then you were given an acting stint after that mentorship?
After the mentorship program, I was then called to come and act a Western Cape. Yes.
Okay. And I've read your judgments. I think they're well written and they're sound, and you apply the principles well.
Thank you, JP.
Yes, and there is a judgment of Kabula, a refugee law matter. It also had an aspect of admin law. I think you've dealt with condonation. You dealt with condonation of the review in that matter.
That is correct.
Application. And have you had an opportunity of sitting in legality reviews?
I did not have an opportunity to sit on any legality reviews.
Okay. So I won't ask you this question because I was going to ask you if you can explain the difference between the assessment of the delay between the two.
I can explain, JP. The difference between the assessment of the delay in PAJA is regulated by Section 7 of PAJA when it comes to a delay. But with legality, you need to look at, there's a Kumalo test there, where you need to look at whether the delay is unreasonable. You also need to look at, when you look at condonation, what was the reason for the delay?
Okay. In an instance where a matter comes to the court, but before the hearing or the judgment is given, the matter becomes moot, does the court, as a court of first instance, have the discretion to proceed on the basis that the matters that are there are important matters that must be, that go far beyond the parties, that must be determined by the court?
If the matter becomes moot, JP, and then you don't go further than that. You won't decide the matter because the matter is moot.
Okay. And you know that our court is losing experience?
That is correct.
And what contribution of value would you bring were you to be appointed as a judge?
I would bring my experience. I've got experience in the different lower courts. I've got experience in the district court, in the regional court, as well as in the high court. I would bring that experience to the bench of the Western Cape. I'm very analytical when I write my judgments. I believe that the various experience in the various fields of law that I have, I would be bringing to the bench.
Okay, thank you. Thank you, CJ.
Thank you, JP. Advocate Boshoff.
Thank you, CJ. Afternoon.
Afternoon, Commissioner.
Correct me if I don't know if this was raised by Chief Justice, but in paragraph 10.1 of the GCB comments, they just they mentioned that there were 4 judgments outstanding at the time of completing your questionnaire. Can you confirm whether you still have outstanding judgments and what their status is?
I've got no outstanding judgments.
Right. Then just a technical question. Can you explain your understanding of the test applicable to the enforcement of judgments pending an application for leave to appeal or an appeal, with reference to Section 18 of the Superior Courts Act and any applicable jurisprudence that you might be aware of? So there's an application for leave to appeal, or there is an appeal, leave having been granted. Somebody then approached the successful party in the court of first instance approaches you in terms of Section 18.3 for enforcement of the judgment notwithstanding the appeal. What approach and what test would you apply?
You would apply the test of the interest of justice. When there's a Section 18.3 and the person has appealed their judgment, it has the effect of suspending their judgment until the appeal has been decided.
Yeah, Section 18.3 specifically also contains requirements. You've correctly explained the default position, but obviously the execution pending appeal is an exceptional remedy, and Section 18.3 specifically sets out factors that the court must satisfy itself with before allowing such an enforcement. Are you familiar with those factors?
No.
Okay, nothing further from me, CJ.
Thank you, Advocate Boshoff.
Just a small thing, Mr. Mthunye. On matter of State versus Rajabu, the review.
Yes, Commissioner.
Yes, do you remember that matter?
Yes, I do remember the matter.
I'm the JP of the Northern Cape. I do not know about this matter.
About the matter?
Yes.
It was a matter where a legal practitioner was struck from the road.
Yeah. This was in the Western Cape, not Northern Cape.
No, it was in the Western Cape.
Yeah, I see the citation is 2025 to SACR 325 NCK. Should have been Western Cape, not Northern Cape.
I don't know. That is how they reported the judgment,
Yes.
JP.
Yeah, it needs to be corrected. No, thank you.
Thank you, JP. Any further questions, commissioners? Minister, then Commissioner Apostle.
Thank you very much, CJ. Good afternoon, Ms. Mthimuni.
Good afternoon, Commissioner.
I see you mentioned in your CV that at Regional Magistrate Court in Stellenbosch, you've dealt quite a lot with sexual offences matters, both for adults and, my apologies, and for minors. Just in terms of your experience, one of the challenges that sometimes we have is the time it takes to conclude these matters. And to the point that some, especially women organizations that are dealing with gender-based violence and femicide, are actually saying that in the process of court processes, there is secondary victimization of the victims. What's your view in terms of the process that we have, while noting that we've got, I can say, principles and dates or timeframes that sexual offenses should be dealt with, the timeframes to avoid secondary victimization? Do you think that we are compliant with that? With your experience, what has been active or your real experience on the ground as a practitioner?
Commissioner, in Stellenbosch, where I acted, it's a very small court. And victims usually meet with the perpetrators in the passages. The the process can be improved in being able to have victims testify via virtual and not actually coming to the court building itself. Maybe if we can make use more of the place of safeties where they have the virtual systems in place, and for the victims then to be able to testify from there, it will then alleviate the issue of secondary victimization between the victim and the perpetrators.
Just to follow up, so your understanding is that the structures that we have, infrastructure is inhibiting. But what about the processes themselves? Do we have sufficient support?
Currently, we don't have sufficient support, Commissioner. And the support, if the support was to be given to the victim, sometimes it takes a long period of time for that victim for the special arrangements for that victim to get the necessary psycho support. I think more can be done in order to make sure that victims get more support in sexual offenses, in sexual offense matters.
I'm asking, maybe I'm asking my question wrongly, Mr. Mthatha. The issue as a practitioner, perhaps, maybe let me say, how do you ensure that within that system or whatever with what assists you to be able to have successful prosecution of those cases, your support in terms of being a magistrate, and therefore, so I wanted to understand from that, what are the elements that perhaps we could learn on how you've been able to have successful prosecution despite what we have as some of the inhibitors?
As a presiding officer, Commissioner, the onus is obviously not on me to have successful prosecution. It is on the prosecution to make sure that they prosecute these matters successfully. As a presiding officer, my duty is to make sure that the victim is not victimized, to make sure that the victim is comfortable when the victim has to give testimony, to make sure that if the victim is agitated and in a state where the victim cannot proceed in open court, then to have the victim testify virtually.
Commissioner Poso?
Thank you, Chief Justice. Good afternoon, Ms. Mtimunye.
Good afternoon, Commissioner.
Yes. Can you tell us how many judgments have you written as an acting judge?
I have written many judgments, over 80 judgments.
And for what period, and for how long have you acted?
I've acted for 38 weeks.
Thank you. Are you aware of the anti-sexual harassment policy?
That is correct, Commissioner. The JPs has made sure that all of us have been applied with the anti-harassment policy, sexual harassment policy.
Did you acquaint yourself with it?
Yes, yes, Commissioner.
Have you any suggestions for changes or amendments to it?
I have made my suggestions at the time when it was requested from the judiciary, the magistrates, to make comments, and I have made my necessary comments to the relevant board.
Thank you, Chief Justice.
Thank you, Commissioner. No further questions, Commissioner? No. All right. I can see your big smile of relief.
We have no further questions for you. Unfortunately not. Commissioner Trolliff?
Sorry, just a question of clarity. Ms. Mtimunye says she wrote over 80 judgments in 36 weeks.
38.
38 weeks.
Mm.
That's like 2 a day. Sorry, two a week. Sorry, beg your pardon. My
But
clarity, thanks.
It makes sense, Commissioner Trolliff. It's possible, eminently possible. All right. Thank you. Thank you for making the time. You're excused.
Thank you so much, Chief Justice, for having me here, and thank you to the commissioners for having me here. Thank you, JP.
Good afternoon, Advocate Njokweni.
Good afternoon, Chief Justice.
Are you well?
I'm very well, thank yourself, Chief Justice.
I'm fine, thanks. We apologize for keeping you waiting.
Not a problem.
Yeah.
Also, good afternoon, I think, to all the other commissioners.
Mhm. Yeah. You hold a BUris degree from the University of Transkei
That is correct, Chief Justice.
and an LLB from
The same unit.
or the same institution, or is the certificate in practical legal training that you obtained from the University of Cape Town? Okay.
That's correct.
All right. You've been an attorney for the most part of your legal career, not so?
That is correct.
You did your articles between 1996 and 1997. Sorry, 1997. And then you worked as a professional assistant where you had completed your period of articles. Then there's a whole lot of things you did. You were a PA at NJ Yegiso and Associates.
That's correct, Chief Justice.
For a year.
Yeah.
Then you started your own practice.
That is correct.
But only for a year.
Yes.
Then returned to
Indeed.
NJ Yegiso and Associates as a director, though.
Indeed.
Was there a merger? What happened? There seems to have been a lot of movement with the Yegiso part.
So, Chief Justice, in 2001, the late Judge Yekiso called me to say, look, he aspires to be elevated to the bench and that I should come back to his practice as a director, and that the intention was to leave the firm to me. And I then went back. Then in 2002, he was appointed to the Western Cape High Court, and I took over the practice. The practice traditionally has always operated from Athlone. And I had always had a desire of attracting commercial work because traditionally the practice was a general practice. And at that stage, we had our first institutional client, which was the Road Accident Fund. And I then deemed it necessary to relocate the firm from Athlone to the CBD in Cape Town, to be in close proximity to the RAF offices. And a year later, in 2003, I was approached by senior partners of Murray Miller at the time for a possible merger. And I must confess that at the time, I only focused, in my work and was clueless about business. All I cared about was doing the work and going to court and all. So without any due diligence on this proposition by the Murray Miller brand, I agreed. And one of the reasons that I agreed, I had some professional assistants and a partner at the time, and who were not pulling their weight. And I felt that I was drowning in terms of capacity. And at the time, you could only invoice the Road Accident Fund on finalization of the matter. So we had a lot of cash flow problems, which constrained me from employing a lot of people at the time. So long story short, I agreed to the measure with one condition, that we want to be exposed to the commercial work. And what happened, we relocated to Murray Miller offices in Adel Street. And later on, I realized that all that changed was the name of the practice and the office where we operated from. Otherwise, everybody sat in their own offices, did whatever they did, complained about this, but there was just no appetite to share any work with us. And what used to hurt me most in that arrangement was that every month and there'll be a director's meeting and fee books will be laid bare. And as we're doing mainly RF work, because of the volume of the work, we cannot do any other work. We will be seen as if we're not pulling our weight, because we're not bringing cash fees on a monthly basis. But when eventually the RAF pays, then everybody is happy. But one day, I realized that many of our white directors were actually posting fees in circumstances where cash was not received. So I encourage my colleagues that they should also post these fees so that we can also get a clap and an applaud in the board meeting. And they were so shocked when we posted 6 million rands and all those kind of stuff. And the chairman said, but where is this money? I said, look, it's still sitting in the coffers of the fund, but where is the money from Mr. X and Y? Because I don't see it in the management reports. And that kind of stabilized us. But in short, I realized this is not going to work for me in that environment. Then I proposed that instead of acting for the road accident fund, maybe we should convert to act for the claimants, because it's more lucrative business. And at that stage, we were allowed by the fund to finalize matters that we inherited from the EKSO practice for the claimants whilst acting for the fund. I just want to pause to mention that immediately after the measure, the senior management of the fund questioned the bona fides of Murray Miller in this measure and suspended us from the panel. I fought tooth and nail to say, we're trying to be empowered and get exposure to other kinds of work, and now you are suspending us. But during suspension, I then requested that we should be allowed then to get instructions to act against them, which they allowed us to do. But my proposition later on to quit acting for the defendant, but act for the claimant, was dismissed by the board, and I then decided that it was time for me to leave that.
All right. Is that when Boshoff Njogweni came into being?
Yes, actually, briefly, the Chief Justice. One of the junior directors at Murray Miller, a couple of them, approached me to say, look, you're very good at what you do within the MVA space. Why don't you start up your own practice? The problem I had again was the capital to start my own practice, because at the time, you know, many medical experts will require deposits in order for them to compile medical legal reports for your client. It is when that Boshoff was introduced to me by one of the junior directors at Murray Miller. He was from the Free State and knew nothing of MVA. He was just a conveyancer. And I managed to convince Murray Miller, or persuade them at the very least, to give me my files, the claimant's files, because they didn't want those kind of clients. And we had a fee arrangement with them, which was very beneficial to me and the Boshoff Njogweni firm to be established. So I went over to that firm with 450 MVA claims, very, very lucrative claims, which I serviced personally. I trained staff and brought in all tools and precedents that I've built over the years for the smooth running and establishment of that division. And later on, unfortunately, I think after a year, with an arrangement that until the portfolio is liquid, he will give me a nominal retainer. And the expiry of the 12 months, he just didn't pay me anything. It disappeared for a good 3 months. And eventually, I asked my secretary then to compile a list of these claims, and he intercepted that and threatened me via security at the bottom of the building.
Maybe we should not go into all this fine detail. It may just get us into deep trouble.
No, sure. Let me leave it there.
Things, let's just leave it at things did not work out.
Things did not work out.
Then between 2008 and 2017, you were a director at various entities whose nature is not clear to me. What were you doing?
Yeah, so a late cousin of mine used to run.
And keep it short, I can see
I'll be very short.
Some commissioners are glaring at me. We promised ourselves to keep things short.
I'll be very brief, Chief Justice, thank you. It was my way of trying to get access to commercial work. I started advertising myself as an attorney that will assist SMMEs with structuring their small businesses in terms of, be it association agreements, shareholders agreements, and relationship agreements, and And these were entrepreneurs that I have known. So they were very active in the market. So they could not afford to pay my fees at the time. So they would offer me shareholding in these businesses as a compensation for the legal work that I'll be doing for them. And most of them never seen the light of the day in terms of business as it were.
So, KMNS Incorporated, Njogweni and Seth Incorporated, Norman Hornby Incorporated, all firms of attorneys. And that's where you were between 2018 and 2022. Then Njogweni Attorneys, back to Njogweni Attorneys again until December 2022. And you finally decided to join the bar.
Indeed.
Okay. You are with the Johannesburg side of advocates?
That is correct, Chief Justice.
All right. Since 2024?
That is correct, Chief Justice.
All right. What kind of work did you do in all of this, legal work in all of these entities?
Well, Chief Justice...
did you appear in court? Well, you mentioned that the bulk of your work was with the Road Accident Fund. What else did you do?
Now, initially, Chief Justice, we did a lot of criminal work and civil work.
All right.
And I appeared in all the courts in Cape Town, in criminal courts, regional court, high court. I've done a lot of civil matters outside the Road Accident Fund, family law matters, contractual law, trust property control related matters. I've done one review where I appeared in Pretoria, and it's very diverse.
All right. And what kind of briefs have you received as an advocate?
So when I got qualified as counsel, I got a pro bono brief involving a family matter with vulnerable minor children. And I thought it was going to be a quick brief. It detained me for a good 6 months at the commencement of my practice. And later on, the legal aid clinic of UNISA, I told them I could not afford to carry on with the brief because I've got to pay my chambers and the bar fees and all that stuff. But fortunately, since 2018, I've never really had a big practice with many clients. I will have 3 or 4 clients at any given year, but I will service them properly. And over the years, they've really retained me to be able to earn a living. And through their word of mouth, they've managed to refer me to other clients. And that has really sustained me. And that's what made the transition from the sidebar to the bar relatively easy, because I did not have to wind up a huge practice with a lot of work.
You still have not told me, other than the brief from the legal aid. What kind of work has been done?
Yes, then my first brief was from one of the biggest law firms here in Sentin, ENS. It is the matter of the MK Party versus the SABC. The brief came directly to me, and whilst I was studying and marking the brief, I was informed that the client, SABC, requires a senior counsel, but I was requested or given at least the authority to select silk myself. And I selected a black silk senior in the matter. And we ran with the matter in Joburg High Court, which was brought on an urgent basis. And the matter was struck off the roll for want of urgency. And the applicants in the matter were directed to approach the Deputy Judge President for early allocation, if so advised. And indeed, they did so, and the matter came back. And again, they lost. And unfortunately, at that time, I was then called to act in the Western Cape Division. And that was my last involvement in the matter.
Okay, you wanted to add something?
Yeah, then I had another brief from a black law firm here in Sentin in the Labour Court. It was my first ever labour matter that I've ever done in my life. And another matter in Cape Town by a Cape Town attorney. And at that stage, my practice was starting to pick up. And Norman Hornby attorneys was a strategic relationship wherein they did a lot of insurance work. And through that relationship, I managed to get briefs within the CPAs and disputes about community trusts. And yeah.
So you've done a fair amount of commercial work.
Not much, but fair amount. And then also, if I may add that when I joined the bar and applied for pupillage, I specifically requested that I be seconded to a mentor who specializes into something that I've never done in my career. And I was seconded to someone who's specializing in insolvency law. And I picked up a lot of experience. And I remember that we ran one of these inquiries for the retired Justice Petersman for good 5-6 months. So I had a nice experience in that regard during my pupillage. And whilst acting on the bench, I've been privileged enough to be allocated matters involving insolvency matters, and I've handled those very well.
And you acted from April until December of 2025?
Till to date.
Or you're still acting?
Indeed so, Chief
All right.
Justice.
And you've sat in all the courts in the division?
All the courts. Actually, I was looking at my stats for the last term. I sat 6 full court appeals, civil appeals. I sat on 4 full benches. I sat on no less than 10 civil trials. And I sat in the urgent court, I think 3 times in the last term. So
any criminal trials?
I have 1 criminal trial that I've ran.
Motions?
I beg your pardon?
Motion court? Well, sorry, motions opposed and
yeah,
unopposed.
I've done a lot of opposed motions. And I ran that 3rd division, the unopposed role. We'll get 70 a day. And in our division, in the unopposed role, the summary judgments, you entertain them. The Rule 43 is opposed, you deal with them there. And sometimes I run until very late, and practitioners always say to me, we don't know how you do it because you run. And that's what I do.
Right. How many judgments have you written?
I've written about 25 judgments.
That's not a tremendous output, considering that you've been there for what, a year now?
Yes, I've delivered a lot of judgments extempore.
All right.
And also, for example, in road accident fund matters, some of these matters settle and there are draft orders. So I've got now picked up from the last term about 8 reserved judgments from late in February of this year, which I've started drafting. So that's what it is. But where I can, I deliver my judgment extempore there and then and give reasons.
All right. You were, let me just keep it short. I see that you were quite, you were a student activist back then. Are you a member of any political party presently?
Not at all. Even at school, I mean, I would be on the side committees, never really in the mainstream of the politics.
Oh, that's not the impression I got. All right. Any judgments reserved for longer than 3 months?
I've got one Chief Justice, which is 3 months and 10 days. And I'm halfway drafting that one. I'm delivering it next week.
All right. All right. JP?
Thank you, Chief Justice. Good afternoon, Acting Judge Njokweni.
Good afternoon, Judge President.
How are you?
I am surviving under the circumstances. Thank you, sir.
Okay, thank you. You've acted in that division for quite a while, and how has your experience been? How did you find the environment?
JP, I found the environment very, very, very safe and very, very encouraging. The colleagues at the court are very collegial, and I make it a point that time permitting, I do not miss attending the tea room, and I've gotten well with the judges and most senior judges in the division. I've sat with many senior judges in the full court and in the full bench, and they've really applauded me for the hard work that I put behind and how I do my research and my effort in putting decent judgments, which all they have upheld. I must also say, but at the beginning.
Okay, I think that's enough for that question. And one of the people who nominated you is a senior advocate who says that you're a person who's very keen to learn. And I think I agree with that, because early on, when you arrived in the division, you asked for advice. You came with your first judgment. We worked through it together. It was quite a long judgment, and we worked through it, and you were open to suggestions. And thereafter, I've seen quite a great improvement in how you write your judgments. And the person who nominated you also says that on the strength of your judgment, one of your judgments, I think it's NJR judgment, the leave to appeal that was intended by the respondent was actually withdrawn because they saw your reasons. I think you gave reasons thereafter, didn't it?
Indeed so, JP.
Okay. And some of the, you've also written a judgment on anticipation.
Yeah.
And can you tell us what principles are involved in when interdicts are sought in those cases?
Well, in that matter, briefly, this was a married couple, and that where the relationship was souring, they decided to sell the immovable property, and the immovable property was sold, and the proceeds of the sale were still in the trust account of the conveyancing attorneys, and the wife then wanted an application to preserve those funds on the basis that the husband, who was a foreigner, I think from Mexico, if I remember well, was about to relocate to Mexico, and that he had a claim against him of maintenance for himself and the minor children, and that he was about to dissipate this fund. And on the analysis of the facts before me, there was no intention that was displayed by the applicant that the respondent intended to dissipate any funds. So it was the intention to dissipate those funds that had to be established, if I remember correctly.
Okay, you've also sat in a matter that has to do with environmental law and administrative law. Yes. You were paired with a senior judge in that matter, and you became a scribe.
Yes.
It dealt with the provisions of NEMA.
Yes.
What was that about?
That was about,
briefly,
yes. The applicants wanted an authorization to bypass the environmental assessment on the basis that there was an emergency situation that was threatening the integrity of the structure of the house. And it was so imminent that if they've got to go through the route of the environmental assessment and authorization, there was a risk of the structure collapsing and therefore causing risk to life and to property. But the evidence that was before us suggested that the expert evidence that it was not there was no imminent danger. If there was any, it was self-created. The applicant ran a 5-star guest house and continued to accept bookings. Actually, the evidence was that they were fully booked for a year. Now, the question was, if it was so imminent, this danger, why they still had to do that? And then what we found on the review side of things was that what served before the chief director and later the minister on internal appeal was there was nothing wrong with the decision they took. They took into account all relevant information, and their decisions were rational and reasonable under the circumstances.
Okay. I'm going to ask the last question. You've done a criminal trial, and have you had an opportunity of making interlocutory rulings?
Yes, indeed. I ran a murder trial, and in that murder trial, one of the accused had made a confession to the police, and he wanted to distance himself from that confession on the basis that whatever was contained in that confession, it's something that the police had told him to write. And then once that the admissibility of that evidence was objected to, then we entered a trial within a trial, and evidence was led on behalf of the state and on behalf of the accused. And later on, I ruled that the confession was made freely and voluntarily without any coercion forced by police.
Thank you, Chief Justice.
Advocate Boshoff.
Thank you, CJ. Afternoon.
Afternoon, Advocate Boshoff.
Just for the record, I'm not the Boshoff from Free State. The judgment that JP asked you about, that's the house in Knysna, right? The guest house there on the dunes. Yeah, I read that.
In the wilderness.
Oh, wilderness, yes. But it's a very good judgment. So just a technical question from my side. Can you explain the traditional result principle as it applies to the awarding of costs, and then also the so-called biowatch principle for us?
Okay. My understanding is that the court has got a discretion on the award of costs, and which discretion must be exercised judiciously, of course. And the biowatch principle, as my understanding, is that if the matter involves a constitutional issue, or that the applicant wants to vindicate a constitutional right, in those circumstances, in order not to discourage litigants from taking constitutional points, the court ordinarily would not mulct that party if he loses with costs.
Thank you, CJ.
Thank you. Anyone else? Commissioners? Commissioner Posoli-Rotul? How am I supposed to see this? Commissioner Mkhanda. You may go ahead.
Thank you, CJ. I've listened to the questions that the Chief Justice posed to you regarding the experience at the bench. My question would be limited to the period that you've been there, knowing that the division has got senior judges that are there. What steps did you take at times to draw from these senior judges without you becoming dependent on them during the period that you've been?
I'm sorry, can you repeat the question, please, Commissioner?
I've looked at the period that you've been at the bench, understanding that the division has got senior judges.
Yeah.
During this period, what steps did you take to draw from these judges so that you learn, but also without you being dependent on them? Thank you, Chief.
100%. Thank you so much, Commissioner. I've been very fortunate to sit probably more than 10 full court appeals with senior judges. In some of the matters I've been ascribed, but I've benefited a lot in the both pre and post hearing discussions with the judges. I've developed a very, very good relationship with them, and they've told me that my humility and my willingness to listen and learn whilst not compromising my independence is encouraging. In fact, they support my ambitions to be elevated to the bench if I am so recommended by this commission. I remember one of the senior judges at the next acting stint in the SCA, and she requested that I should occupy her chambers, and she left me with a lot of pretrial matters. And when she came back, she was very happy how I handled those pretrial conferences and the notes that I've made in her file. So I'm always engaging with senior judges, debating whatever issues, or if I've got a complex issue, I'll go and have a discussion, but ultimately the decision is mine.
Thank you, Chief Justice.
Thank you, Commissioner Makhanda. Commissioner Poso.
Thank you, Chief Justice. Advocate Njogweni, good afternoon to you, sir.
Good afternoon, Commissioner.
Yes. Just clarify for me, what is the status of the LPC complaint?
That complaint was disposed of long time ago. I've attached to my application the decision of the LPC and the decision of the bar.
All right, thank you.
Thank you, Commissioner.
Now, can you please tell us, as an acting judge, whether you're aware of the anti-sexual harassment policy?
I am indeed, Commissioner.
Have you acquainted yourself fully with it?
I've fully acquainted myself with the contents there.
Do you subscribe to it?
I fully subscribe to it, Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner Poso. Commissioner Steinberg.
Good afternoon.
Good afternoon, Commissioner.
In your questionnaire, you asked about the most significant cases that you appeared in. The first one is S.V. Hammond.
Which one is?
S.V. Hammond. Hammond.
S.V.
Hammond. Hammond.
Okay, where do I find that? I don't recall.
Secretariat, will you please help him?
Page 17 of your application. Annexure B to your questionnaire.
Okay, now B1, you said, Commissioner.
Annexure B on page 17.
32, yes.
S.V. Hammond.
I don't have that here.
Hmm?
I've got page 32, but the case that you're referring to.
I've done exactly. My sincere apologies to the chair. The only one I don't apologize to is the minister, because she's quite pleased. My apologies, sir.
Thank you, Commissioner.
So is the question withdrawn then?
Withdraw.
Any further questions for Advocate Njogweni, commissioners? I think we should end the interview on this note.
Thank you so much, Chief Justice and the
Thank you.
Commissioners.
Thanks to you. All the best.
Thank you.
You're excused. O'Brien.
Good afternoon, Chief Justice and Commissioners.
How are you?
I'm well, and yourself?
I'm well, thank you. May we start?
We may.
All right. You hold 2 degrees from the University of the Western Cape, a BUris and an LLB.
Correct.
Your legal career, I just want you to explain, you had a stint with SAPS.
Yes.
At the very beginning of your career.
Indeed.
Can you just explain that briefly?
What happened, Chief Justice, was that I got a bursary from the then Administration of Colored Affairs because my parents could not afford to pay my university fees. They gave me the bursary, and the conditions of the bursary was that I either pay the money back or I start at some institution, which would be the equivalent in the legal field, and that's how I ended up in SAPS.
Directly thereafter, you were employed by the Department of Justice in Namibia.
Indeed.
As a public prosecutor.
Indeed.
For a period of a year. Then you returned home and continued as a public prosecutor with our own Department of Justice.
Indeed.
Until 1991.
Correct.
Then in late 1991, you joined the magistracy.
Correct.
And you remained there. Well, you worked your way up, became a regional court magistrate for a period of, was it 2 or 3 years?
2.5 years, Chief Justice.
So in the magistracy, you were in the magistracy for 9 years.
Correct.
Sitting in both the civil and criminal courts.
In the match court, both civil and criminal. In the regional court, only criminal. At that time,
yes,
the regional court did not have a civil jurisdiction.
Yeah, we recall. All right. Then you joined the Cape Bar in 2001, and that's where you've been until now.
Correct.
And what kind of practice have you run?
Chief Justice, my practice initially started out as, obviously because I was in the regional court, attorneys would brief me on criminal matters. After that, state attorney got to know me, and I started getting briefs from the state attorney. And the state attorney has been my source of income for all these years. If it wasn't for the state attorney, I would not have been here.
You're quite lucky because a number of people, candidates who've appeared here, and some I know from elsewhere, have complained bitterly against the state attorney. They say the opposite. So it's good for the minister, I suppose, that there's someone who can say he was sustained by this office of ours.
I'll have to add something on that, Chief Justice. What has recently happened, and Mr. Boshoff is here, the provincial government in the Western Cape, I don't know how it happened, but they are going to appoint private firms to do the work of the Western Cape government. And I don't know whether it has kicked off, but it will definitely have an impact on black counsel at the bar.
All right. You have acted as a judge for about 16 months, as I counted it.
I would prefer to count the terms.
Yes.
It was 10 terms, and I'm currently busy with my 11th term. Previous terms were in the
You mean
northern...
you're acting as we speak?
Yeah.
Where? In this division you want to join permanently?
Indeed.
All right. So how many terms you say it has been?
10 terms and busy with the 11th.
11th. All right. Spread among the 3 divisions in which you've acted, because you've also acted at the Northern Cape High Court and in the Free State High Court.
That's correct.
All right. So how long have you acted in the Western Cape division?
In the Western Cape, I started in October 2017 until the December 2017. That was the last term. And then last year, when the JP requested advocates to do pro bono work as judges, I volunteered. And after I volunteered, I got an opportunity to act in July until September, and then from the beginning of this year till the last term, and then currently.
All right. What kind of cases have you adjudicated in all 3 divisions?
I've sat in basically all types of matters that usually comes to the High Court. I've sat in full court appeals, both civil and criminal. I've done civil trials. I have done a criminal trial as well last year. But in the Northern Cape, my calculation of the criminal trials, I think it was about 6 or 7 criminal trials I did in the Kimberley High Court, which is obviously not in Kimberley, but on circuit.
Yes. All right. And how many judgments have you written?
Chief Justice, I tend to give a lot of extempore judgments, which I have lost track of. Written judgments, I would say in the region between 45 and 50.
As a magistrate, you were a member of JOASA, I see.
Yes.
And now you are a member of the Advocates for Transformation.
Correct.
Okay, since 2001. Right. You state that, you state that your most significant contribution to the law and the pursuit of justice in this country of ours is the amount of time you've spent which in the legal field, which spans over a period of over 42 years. And you mentioned two particular activities you were involved in. One being an initiative meant to reduce case backlog at Mitchell's Plain Court at the request of the late Minister Dala Oma. And you say you did that work for no pay. You sacrificed your time, your weekends, and the objective of the initiative was achieved. The backlog was reduced significantly. Then you also mentioned tutoring pupil men. Oh, I'm tired. I'm sorry. Advocate. Tutoring pupil members in criminal procedure in your early days at the bar and pro bono work you've done as counsel and as an acting judge. So that has been the extent of your plowing back to your country. All right. I'm going to hand over to Judge President Mabinja Pokwana.
Thank you, Chief Justice. Good afternoon, Acting Judge O'Brien.
Good afternoon, JP.
How are you?
I'm well, and yourself?
Very well, thank you. You've acted for a couple of terms in our division, including this term. And I also see that you've acted, maybe before I go to that question, you've done pro bono work, which you've also talked about, even during recess, which we commend you for that. And
thank you.
Available when there's a need for someone to come in and assist.
Thank you.
Yes. You've also, I see in your pack, you have personally compensated a black pupil when you were mentoring them. Can you talk more about that? You don't have to mention their name.
Yeah. The name of the particular person appears in my pack. She said I can mention the name, but I'm not going to do it. JP, transformation, and I've noticed, and what I'm going to say might be a bit controversial, is that one should not pay lip service to transformation. One must actively engage in transformation. If you transform from your personality transform to the values of the new South Africa, then you're going to have more black friends, you're going to have more engagements in the so-called locations, and on a professional level. This particular lady, as she put it in a letter of support, I was there for her since in her inception. In the matter, she did deviling work for me. She also, in the matter where I personally paid her from my fees, I spoke to the attorney, and attorney spoke to his client, and they were happy with the arrangement. And so it's easy for people to come and say we are applying transformation. But I've never seen, I heard about fee sharing. People do fee sharing, I appreciate that. But to the extent that that they just pay lip service, I'm against that. And you know what also boggles me is that there was I belong to Advocates for Transformation.
Okay, I was just asking that one. Just in the interest of time, unless it's very important for you to mention that, but I was just asking that particular question regarding that pupil, which is something to be commended.
But may I just say this, JP? There was a time when Advocate for Transformation wanted to be part of the Cape Bar Council, 50%. And it's a fact that at that meeting, we were outvoted. It was only when the GCB came on board and the GCB did not accept the Cape Bar's proposal that it shouldn't be the way. And lastly, I couldn't approach a person because he was an acting judge and I did a matter in front of him. I was brought in a matter where he acted, where he was counsel. They wanted someone who was senior. It was a black male. It was a very intensive matter, 52 plaintiffs. I started the process of cross-examining witnesses, and by the third witness, I said to him, "Fellow, you must now take over," which he did with flying colors. So you need to give also opportunity. Thank you.
Thank you, thank you. Have you sat in administrative law matters?
Excuse me?
Have you done any administrative law cases as a judge?
Yes, I have done. In the Northern Cape, I've done. In the Western Cape, I haven't done recently, but as counsel, I've been involved in administrative law quite recently in a case which is still pending.
Can you tell us about self-reviews?
Self-review. JP, self-review is where the organ of state, let's just call it, did something wrong in terms of their powers, and they want to rectify that. The Kajima says, a case says that you can only do that through a legality review and not a PAJA review, because a PAJA review is for private persons. In other words, the state cannot clothe itself with rights.
What do you understand with what has become known as the clearest of case test?
JP, that issue came up in the outer matter where where you sought to obtain an interim interdict against the state. And the court said that you can only do so in the clearest of cases in exceptional circumstances. In other words, you have to make out a pretty good case, because you must be careful not intruding on the separation of powers principle.
Is it in every case where there is an interdict sought against exercise of public power?
Can you repeat that, please?
Would that be applicable in every case where an interdict is sought against exercise of public power?
No. Obviously, in interdiction with regard to private people, private citizens, the prima facie right applies.
Okay. I saw from your pack that, or from the questionnaire, sorry, that you also had a couple of terms in other divisions.
Yes.
And Northern Cape and Free State. And my question that I had was, given your age, why did you not apply in Northern Cape? Because you acted actually a lot more than you have in our division.
Yes. I did apply, firstly in the Western Cape. I was not shortlisted in 2017. The reasons I don't know, I didn't ask. In 2021, I think.
In the Northern Cape?
No, that was in the Western Cape.
And now my question is, why did you not apply in the Northern?
In the Northern, in the Northern Cape, I did apply, but I wasn't shortlisted.
So it's not a question of you thought maybe you'll wait and then maybe this was the right time to do so.
Correct.
Okay. You are 65, and one would say that perhaps age is not on your side. What would you say to that?
JP, I have a lot of experience. I have extensive experience in running trials, criminal trials, civil trials. Judicially, I'm ready. And I don't need to have institutional acclimatization. I can hit the road running. I can also help juniors, not that I proclaim to be a senior judge if I were to be appointed, but juniors can come to me because I know quite a bit of criminal law. I know quite a bit of civil litigation.
Thank you, Chief Justice.
Advocate Boshoff.
Thank you, Chief Justice. Afternoon, Advocate.
Afternoon, Commissioner.
I'm not quite sure what the context was that led to the comment of the Western Cape government's decision regarding a panel of attorneys, but I don't think this is really the appropriate forum to be going into matters regarding my employer and so on. So I'm just going to ask you a technical question. In a recent SCA decision, NAD Property Income Fund v. Sanral, and having to deal with the question of reasonable compensation in the case of expropriation of property, the court reiterated the fact that expropriation-related compensation in South Africa sits at the intersection of statute and the Constitution. In this regard, it referred to the two-stage inquiry outlined in the case of the Toy, the Minister of Transport. Can you please explain this two-stage inquiry to the Commission and what it entails?
Commissioner, I'm going to be honest with you, I don't know about the case. If that case type of case should present itself before me, I will go and study and prepare on it. I will look at the facts. I will look at the law like I did in all my other cases, and I will apply the law.
Nothing further. Thanks, CJ.
Thank you, Advocate. JP Kalisi.
Good afternoon, O'Brien AJ. Let me also exercise my bragging rights that I know you.
Good afternoon.
No, I couldn't recognize you. Your facelift.
Good afternoon, JP.
Thank you. Just two aspects that I just want to clarify, lest they not be understood. The Southwest Africa Department of Justice then, did you apply there, or was it still under the administration of the Republic of South Africa then?
It was a strange situation.
Yes.
In Namibia. It was before independence.
Yes.
And all the regions had their own administrative body. And I worked for the government of Rehoboth. But that portfolio fell under the Department of Justice, the National Department. But I was paid by the Rehoboth Authority.
I missed the Department of
Justice.
That you worked for?
No. I worked for what they call the government of Rehoboth, which was a separate, it's like the old Bantustans.
Okay.
Where you would work for that particular institution.
Okay. And then the second question relates to the case you referred to, Van Niekerk nomino officio versus the Minister of Health, Northern Cape, and you say a cost order on appeal was set aside. Can you explain the circumstances?
JP, the circumstances was that it was a very long case. It was a medical negligence case. There was a child who sustained cerebral palsy, was basically a vegetable.
Yeah, I did sit on appeal. I just wanted to relating just only to the aspect of cost,
Cost.
not the facts and the history.
So I'm just going to make it short. So what happened was I found for the, obviously for the child, and then there was an application in terms of Section 18.3 of the Superior Courts Act for immediate enforcement. Before that application, there was an agreement between the parties that they will pay an interim payment. And that interim payment was made, and I just felt that the whole basis for the 18.3 application fell away. And I made the cost order that I did not grant a cost order, but what I did also, I said that for the benefit of the taxing master, in view of a vulnerable child, in view of the agreement between the parties, the litigation afterwards was totally unnecessary. And I said for the benefit of the taxing master that the any cost should not be deducted from the capital amount of the child. So that's the background of it.
It did not have to do with Calder Bank.
It also dealt with Calder Bank,
Yes.
and I refused that application as well.
Yes. But the issue was that it was not argued. In that confusion, it was decided, and then the argument was that it was not argued.
Yes, yes. I noticed that you sat together with Judge Lever on the appeal, so I do follow up my cases.
Oh, you
and
did?
I respect your decision. I accept that the appeal system is for judicial development and it is for judicial education. So in other words, it's not just, what I'm trying to say is that I humble myself before you regarding that decision.
Yes, and then the Santani, is it the Santani matter that was at the labor courts? I was the DJP there. You appeared before me, and in colloquial language, you won the case.
No. I didn't win the case, JP. I tried to win the case, but it was where a commissioner of the CCMA or other body overstepped the mark.
Yeah.
And I tried to convince you, but it was in vain.
Thank you. It is reported.
Yeah.
Thank you, Mr. O'Brien. Thank you, Chief
Thank you,
Justice.
JP. Commissioner Boswell-Mirotur.
Thank you, Chief Justice. Good afternoon, Advocate O'Brien.
Good afternoon, Commissioner.
As an acting judge, you are aware of the anti-sexual harassment policy?
I am indeed aware. I also signed the declaration that was distributed by the Judge President, acknowledging my awareness of the policy. I can also mention that I was part of the, and still is, of the Sexual Harassment Committee of the Cape Bar, and I have experience in that regard as well.
Thank you, Chief Justice.
Any questions, further questions, commissioners? No. Well, thanks very much for your time, Advocate O'Brien. We've reached the end of your interview.
Thank you
You're
to the
excused.
commissioners. Thank you to the JP, to Chief Justice and the JP. And I just want to thank the support staff for the arrangements that had to be rearranged, and
Yes.
they were quite efficient.
They were. And thanks to you for bearing with us.
Thank you.
Thank Advocate Van Sale? Yes, Advocate Van Sale.
Good afternoon, Chief Justice.
How are you?
I am nervous, but looking forward to this interview. How are you, Chief Justice?
I'm fine, thank you. You don't need to be nervous.
I know that I'm the last candidate in a line. You've had a very difficult and long stint.
And because of that, you're likely to have a shorter, easier interview, but I'm not promising anything.
That is nevertheless music to my ears, Chief Justice.
You studied law at one of my favorite places, Bloemfontein. You're at Govsis.
Yes, I was at
University of
Govsis.
Free State. Mhm.
Yes, I was in high school there, and
Which high school did you attend?
I attended the Oranje Meisie School, Oranje Girls School there. I was in boarding school, and I remember that I wanted to go to UCT, and my parents said, "No, you go to Bloemfontein." At that point, and I was very grateful and glad. It was I received a very good education there, and met a lot of people, especially in the legal fraternity, that I still have contact with.
Yeah. I lived right next to Orania for 5 years when I was still down there.
Ah.
So it's a great school. You ended up going to Cape Town after all, so you got your wish.
I did. Yes, I was looking for articles after having completed my LLB. Couldn't find any, and then had an opportunity to tutor at the University of Cape Town, and that is how I came to
The
Cape
rest
Town.
is history.
Yes.
Right. So you say you completed a year of school for legal practice, passed all the requirements for admission as an attorney.
I did. When I was at the after my serving as a tutor at the University of Cape Town, I went to work as a legal administration officer at the Western Cape government, and it was during that time, especially in the night school, because I was working during the day. I attended a year of night school for legal practice, and after that year, I wrote the attorney's examinations, passed all of them, although I never practiced as an attorney.
All right. So you did your pupillage and joined the bar.
I worked first at Joburg municipality for a few years, and then
as a legal administration officer.
As well, at Joburg municipality, I worked as a legal advisor.
Yes.
Advising council in planning, amongst other issues. That was just before the unification of the city of Cape Town. So it was a very interesting period.
Yeah.
A lot of legislation coming in that needed to be filtered through and explained to the officials who had to implement it. And there I met some advocates who normally, it seemed to me at that stage, had the nice jobs going to court and litigating about these issues, and I wanted to join them. So I went to the bar in 2001.
So you had a bit of diverse experience by the time you joined the bar.
I did.
Greenhorn.
Yes, yes.
So you've been a practicing advocate since 2001.
Yes, at that stage, our pupillage was still 6 months, or about 5 months, and we wrote the general bar examination, I think at the end of May. So I started practicing as an advocate in June 2001. I can remember I had no work for half a year until somebody gave me an opinion to write.
How did you survive?
I was married at the time, which was a great help. I had that support. There was also now and then at that point, I'm sure that everyone in this room will remember, legal aid used private practitioners to do their work. So I often had legal aid appeals on Friday mornings. That kept me going. Yes, it was a difficult time.
Yeah.
Especially I think one forgets at that time, it's because time flies. So it doesn't feel that long ago, but it was a time when it was difficult for women at the bar. And I regard myself as fortunate, even though I had a difficult time. It was a cruel environment. It was chauvinistic. It's become much better, and policies to address the various challenges at that time have made great strides in making things more easy for women. I cannot imagine what Black women went through. And I know that from many of the Black women, for example, who started doing pupillage with me, left the bar after a while because they simply couldn't get work. It was also a time where I had my children fairly soon after starting at the bar, about 4 or 5 years after starting at the bar. And attorneys would look at you askance if they saw that you were pregnant. It was before the maternity policy at the bar came in. It seemed like they thought that your brain was gone with everything else. So I had to deal with that as well. I'm proud today of,
Yeah, you should be.
Of my children.
You've run a mixed practice with legal criminal work, the significant portion being administrative law, as you describe it.
Yes, most of my work when I do practice, and these days it's only for short stints. Most of the work relates to administrative work or general civil litigation. I've never done much criminal work. In the beginning, as I've mentioned, I've done a lot of criminal appeals and I've done a long-running criminal trial, but that was long ago. That was early in my career. Obviously, since 2022, when I started acting, that has taken up most of my time.
Yes.
I haven't really been able to see briefs, long-running briefs through. So I've taken on where I can matters which has shorter spans, or I've tried to concentrate on what my first love in any event is, writing opinions in the case of practice. Mostly.
Right. So you say you started acting in 2022?
I started acting in 2022, Chief Justice. I have in my application form set out the terms and I've calculated the weeks, and it comes to about 90 weeks of acting if one doesn't take into account, it's 9.5 terms in total.
Yeah.
So I am acting at the moment. I've started beginning of this term, which started this past Monday. And
you are still acting as we speak?
I'm acting as I'm sitting here. And I will act until the end of the term, which is I think on the 19th of June. So I have, if one simply looks at the formal appointment periods, that would make it about 2.5 years of acting. But of course, as you know, in between one deals with part-heard matters on an ad hoc basis, writes judgments, gets drawn into other things. For example, I've only done that once, but I'd love to do that again. I was asked.
I'm sorry.
Excuse me, Chief Justice, I didn't hear.
Just repeat that.
One sometimes gets asked to assist at court. I have, for example, done a day of urgent applications, and then obviously everything that flows from that. I would love to do that again, and my services are obviously always available for that sort of thing. But that is in between the acting stints.
All right. You've sat in both the criminal and civil and civil courts.
I've done mostly civil work during my acting stints. I've done one criminal trial. I have included the judgments both on merits and on sentence in my application. It was a troubling matter involving murder, robbery with aggravating circumstances. But I think the fact that I have not done any further criminal work during my acting stint, it was not for lack of asking. I suspect that because of the huge backlog, both on the civil side, the court, as well as the criminal side, my services and my experience as primarily a civil lawyer was needed on the civil side. And I know that there is a very successful criminal backlog program running at the moment, and for the purposes of that, dedicated and I think experienced criminal magistrates, for example, are being used, and trials are being run at for example, Bolesmoor and at the Wynberg courts. So that project seems to be going well. I would love more criminal experience.
Yeah, it is important. Have you done any criminal appeals?
I have done many criminal appeals.
Written judgments in those matters?
Written judgments on those matters. There is, as far as I can now remember, at least one of those has been reported. It's the matter of Yossi. I shall just get to that. Yes, I've done about 10 criminal appeals, in which I was the scribe in 7 of them. And in the matter of Yossi, I was the scribe there, and that is a reported matter.
Yeah.
Justice Gamble sat with me on that one. It was an interesting matter because of the fact that the accused had spent the extraordinary amount of 9 years in detention before he was convicted in the magistrates' court, in the regional court. And I found that to be a substantial and compelling factor to depart from the minimum sentence in that matter.
All right. You've presided in the tax court.
I did, and I presided once in the tax court. It was a difficult matter because it involved the interpretation of a fairly newly introduced rule in relation to what a taxpayer may appeal against. That matter has also been reported. It is in my pack. It was in fact in my application form. That was the first matter that I mentioned. Taxpayer B versus Commissioner for SARS. Now that matter was taken on appeal to the full bench, which upheld my decision, and I was recently very grateful to learn that the Supreme Court of Appeal upheld the full bench decision.
Yeah.
In other words, my decision stands.
That is most gratifying. You've written about 90 judgments, you say?
I have by now 90 judgments. That was, I think, when I previously applied in October 2024, Chief Justice. I have in my application form mentioned 163 written judgments. I have in the meantime written more. They stand at 170, as I said. Yeah.
And how many of them have been reported? Hopefully that the number has increased in that regard as well.
14 of them have been reported, 14 judgments.
Okay.
And I am very grateful once again. I'm being told by my colleagues that they find the judgments useful, that they use them, And my colleagues at the bar also tell me that, thank you for that judgment. They phoned me this. Thank you for the judgment. It's helped me in the preparation of this case, which is the aim after all of writing.
Of course. You have listed a number of activities you do as community outreach, ranging from paying school fees for school fees and college fees for an underprivileged youth, mentoring pupils, sharing fees with previously disadvantaged
Yes.
junior colleagues, being a member of the BLA's
Education.
panel of is that the education arm?
It's the, yes, I was once invited to take part, it was a year or two ago, invited to take part in an education drive by the BLA. Unfortunately, by the time they let me know that that the sessions are underway, it had already started, and I couldn't fill in from that point onwards. But then I indicated to the person with whom I communicated that I would love to be on the education committee of the BLA because I would love to assist. And she accepted and confirmed to me that, yes, I am on the committee. So I am available to mentor and to lecture should I be required to do so.
As I recall, the last time you appeared before this body, you were taken to task. Well, the law bodies, not this body itself, had taken you to task. On your transformation credentials, and I see that you you learned a good lesson. You've listed everything you've ever possibly done.
I
plow back.
Sorry for I obviously I took the comments of the committee very, very seriously. And I did introspection. I spoke extensively to colleagues and to friends. I have never been in the habit of writing things down because I expect something in return for it.
That's how it should be, but not when you're applying for a job in competition with other people, and
yes,
your contribution to your society
Yes.
is at stake.
Yes, of course, and I realized that, and I have thought about, because I remember one of the issues was, well, what is transformation? And I have come to the realization that there isn't really there isn't a fixed definition of transformation. If you ask different people, you get different answers depending on people's circumstances, quite naturally. But what the view that I would subscribe to of transformation is a substantive and an integrated way. In other words, while one could say that transformation in the judiciary is that the judiciary should reflect the demographics, race and gender-based demographics of South Africa, one must not forget that transformation, it all binds into, it all flows from the Constitution, and therefore the application of transformational issues through the Constitution must filter through in what one does, not only in courts, but in civil society and in one's personal life. And there is much that I and others can learn through this process. It's a way of thinking, and it's a way of thinking that we need to cultivate. We need to change notions that are outdated. That is something that needs to be worked on consistently. And it doesn't only fall on individuals, as I said, it's the duty of the courts, the legal fraternity as a whole, business, society. But when I speak of society, I think that we all see how broken society is at the moment. One thinks of issues, gender-based violence, whistleblowers being murdered, sexual harassment, the breakdown of local government in that people do not have access to basic services. So in dealing with transformation through the courts, one must be mindful of all of these facts, and then that those law and life aren't separate. They are intertwined. And that is why I've tried in both my personal and my professional life, as well as, to show what I have done. What I've not mentioned in my application form is, for example, that I am the mentor to a young Black practitioner who has recently started up her own attorney's firm. She is excellent and she loves doing her own litigation. So apart from being able to advise her on pleading and matters, I am able to advise on how to approach litigation. I'm also mentoring a student at UCT who I often invite with me to court. She has an intense interest in a life in the law, and she will be an excellent asset to the profession. Those are just examples of issues in my private life. Or in my professional life, you will have seen also from, for example, one of the persons who nominated me, Advocate Sibineli Koza, mentions that I have mentored him. The letter is on file. I trust that you are in possession of it.
Yeah, we have it.
So I'm not going to take you through that. The other aspect that I feel very strongly about is, and that is an aspect for which I think our Judge President needs to be commended, is that there is now a help desk at the Cape Town High Court for litigants who appear unrepresented in, for example, the motion court, and who needs legal assistance. I have joined that. It's called the Pro Bono Organization. I've joined that organization and I regularly serve there. I see many people, when I am there, who don't only come from directly out of motion court because they have a problem, but also come because they know that they can find help there. And these are vulnerable people, low income people from very disadvantaged societies. And one sees there how far certain portions, or maybe generally how far the law is removed from the society, the challenged society of which I had spoken earlier. The law is removed. I have received a lovely message, if I may, just on a personal level, from one of the persons that I had assisted there, who said to me I was the first person who had truly listened to her, and I had given her hope to continue her case. And I had, in fact, through my mentee, the attorney of whom I've spoken, I've been able to find an attorney to assist this person in court, and her case is going ahead. And I feel very grateful for the opportunity to have assisted her in that sense. And if I don't want to be long-winded, but if I may turn to my personal life, because I've mentioned that law and life aren't separate. They are very much entwined. I love education. I donate school books to a junior school on a regular basis.
You have mentioned those things in your application form.
Then I'm not going to go there because you know that.
You have ticked the transformation box.
If you tell me that, because I always think that one can never do enough. But
Of course.
if I've only ticked a little part of that box, then I am grateful that you are saying that to me, and then I am persuaded to try even harder and tick it even better.
All right. Well, unfortunately, there is a matter, you would be aware of the objection that was brought against you.
Yes.
Our objections committee will discuss that briefly with you.
Yes.
Good afternoon, Advocate. You're aware that the complaint relates to your judgment in the Latari House versus Tabiso Danka and others.
Yes,
You're aware of that?
I am aware of it. I have read Mr. Liu's complaint to that. I trust that you have my response to that.
Would you like to tell the Commission about it? Essentially, it says the complaint relates to the fact that the matter was set for trial, it appears, for the first time. And Mr. Logan came to court on the day. And you told him that he could not participate in the proceedings.
Yes.
He remained in court. He came and asked for an adjournment in order to get legal counsel.
Yes.
Or to get an attorney. Your response was that his application for postponement was denied. The case proceeded on the day.
Yes.
And then default judgment for 1,250,000 was granted against him.
Yes. Yes. Commissioner, thank you for that.
And then the end result of that was that he applied for rescission subsequently.
Yes.
And the rescission was granted and the case then proceeded. I don't know if the trial is finalized, but probably proceeded for trial.
No, Commissioner. Rescission was granted by agreement between the parties. You've all seen my response to the objection. I won't go into detail. If I may sketch the background, the incident which gave rise to the matter occurred in December 2022. Summons was served in February 23. The matter was set down for default judgment in April 2024. Let me just make sure of my dates. No, it was served in February 2024. It was set down for default judgment on the 24th of April 2024, but was removed from the roll. On the 24th of July, again, there was an appearance before one of my permanent colleagues in court, and by agreement, there was an order by agreement between the defendant, I'll call Mr. Logan, the defendant's attorney, and the plaintiff's attorneys about certain issues that had to be dealt with before the matter was again set down for hearing on the 18th of October, which was the date when it was before me. So it wasn't the first time that it was in court. And as you've rightly pointed out, on the day, Mr. Logan was there and he asked for a further postponement in order. He didn't do anything about about the court order that was granted on the 24th of July, if I may add that. I don't want to say too much about the merits of the case because it hasn't, I know that there's a trial date, but it hasn't been heard yet. But in any event, I was not, in the exercise of my discretion, not convinced that he had made out a proper case for a further postponement. A long time had already passed. That was one of the issues that was in my mind, and the explanation that he gave me on the day didn't, in the exercise of my discretion, did not satisfy me that it should be granted. I readily concede that if I think back to the matter, obviously, in the exercise of a discretion, different reasonable judges could come to different conclusions. But I do, if I've made a mistake, I have no problem admitting that. I'm grateful for the fact that the safety net of rescission, of which I had informed Mr. Logan at the time, was there. And I am very glad and grateful that he took the opportunity to do so. But I did exercise my discretion within the facts that were before me at the time. I was also mindful of the fact that the rules of court are there to retain order in court. The roles are full. There is an enormous backlog. There is much pressure on judges and acting judges to finalize matters, not to push them down the line for other judges to deal with. The matter raised serious issues. You would no doubt know that the matter related to certain defamatory statements made. It was a serious matter. But as I say, with the benefit of hindsight, if I've made a mistake, I have no problem acknowledging that. But, Commissioner, that does not make me unsuitable for the position of a judge. I have dealt with hundreds of matters, apart from all of the judgments that I have written. And this is the first time that I've faced an objection like this. I must say as well that I chastised as I am in relation to the way that I exercised my discretion, I was very much hurt by the slant of racism that was placed in, perhaps unintentionally, in the objection, because the people who know me well, know that is simply not true. I do not know whether the committee has received the letters of support or of comment on that specific aspect of whether I was untransformed and racist in my approach. I must point out that Mr. Logan is a white person, but he was acting the narrative is that he was acting in defense of a black person.
I think the criticism relates to the fact that was this matter set down for the first time on your day, for trial, in other words. So it appears that that would be the crux of the complaint, and that I presume the plaintiff was represented and Logan was not represented at the time. And
yes,
the criticism relates to how you exercised your judicial discretion at the time. So that's the main crux of the complaint.
I agree with you, Commissioner. I think if one looks at the complaint as a whole, it is about the way that I exercised my discretion. And at the time, I exercised it on the basis of certain facts. If I had to do it now, I would again consider the facts. I would be very careful. I would have learned from my experience.
Thank you, Commissioner. Thank you, Advocate.
Thank you,
Chief Justice.
Thank you, Commissioner.
Is it a follow-up?
Yeah. Thank you, Chief Justice. Advocate Van Zyl, sorry, I read your response, and I'll be frank, I was actually a bit frustrated at your apologetic tone at the end, because a few things stood out to me. Firstly, the complainant, or Mr. Logan, was not dismissed out of hand. He was given a hearing on the issue of whether or not the matter should propose.
He was certainly not muzzled, as he says in his complaint.
And he was on the from the transcript that I read, it was clear that you explained to him very much his options going forward. But also it appears to me that technically he was still actually being represented by an attorney on record, because there had been no formal withdrawal.
That was what was before me at the time.
And
you are correct.
And just the big thing for me is the rule regarding being placed under bar. especially automatic bar, where you don't even file an notice of intention to defend, is there for a very good reason. And it's there also, because the absurd, if you take this to the extreme, it could potentially lead to an abuse of the judicial system, where plaintiffs or parties who are in trouble can simply have their attorneys withdraw the morning, and they show up and then they say, please postpone. And the problem is, this was already postponed in order for him to get his house in order, because he was rushing back from the US where he was working. It's not like he's impecunious with, off the streets or something. So, I just want us to also just get the context correctly. And I have to actually take issue with the fact that you are so apologetic about this, because the court must also stand firm where it's being abused.
That is true, and I'm grateful for those sentiments, Commissioner, because it's no use being a wimp as a judge. One must, as you rightly point out, the rules are there to maintain order. But I know that one tries to bend backwards for litigants who appear before ones, but as I've indicated in my explanation, I had certain facts in front of me. I certainly did not treat Mr. Logan with indignity. I explained these rights to him. And as you point out, yes, although he appeared there as an unrepresented person, he was in fact still represented. And he was represented in an equality court matter that was apparently running at the same time. So I'm grateful for the sentiments, and I take your criticism of me backing off in a sense. I appreciate those sentiments.
Thank you, Chief Justice.
Well, speaking for myself, I was satisfied by your explanation, even without Advocate Boshov's intervention.
Thank you, Chief Justice. I appreciate that.
Had you finished, Commissioner Shivan? Okay, thank you. JP Mabindla.
Thank you, Chief Justice. Good afternoon, Acting Judge Fonseca.
Good afternoon, Judge President.
You've acted pro bono also in our court, and that included the January 2025 period where we called upon you because judges had a session that they had to go to.
Yes.
And you stepped in.
I think, Judge President, I've told you once when you threatened to burden me with more work, I told you that getting work was like getting presents. One opens a file like unwrapping a present to see what is in there and what one can resolve. So I gladly stepped in, and in the urgent court, it was a busy urgent court, and I did the work.
So I can see why you have 170 judgments, because you don't say no, which is probably not the right thing, because we will always have work and we will always need people to assist.
I also thank you for that, Judge President, but I do have a very fulfilled private life as well. You from our discussions in the tea room, you might know some of my activities. And I've pointed out in my application form as well that I am a musician, and I'm also involved in just become involved in training.
You also dance.
And I dance. I love ballet. Yes.
Yes. You're very active in the pro bono help desk of the court, which was established in August last year.
Yes.
And can you perhaps tell us more about the role that you played in the establishment and maintaining of that help desk?
Well, I've previously contacted that organization because and that was before the establishment of the help desk, contacted that organization because I wanted to become involved more in giving advice to persons who do not have access to justice. And I could tell you the reason for that. I've been toying with the idea, which I think would perhaps be a useful contribution to the legal field. It seems to me that there's a huge divide between those who can afford legal services and those who cannot. And very often our adversarial system of litigation is very it undermines the rights of people who cannot afford lawyers or the best lawyers, and an inquisitorial or a mediatory system would be much better to resolve the disputes and the problems that people have to deal with on a daily basis. And I was wondering whether there was some scope for developing the law. I know that much stride has been made on the issues of mediation, but one could look at more inquisitorial aspects. But that is a discussion. So I had approached that organization, and then shortly thereafter, I was informed that the help desk was now up and running at the High Court. So I jumped at the opportunity of becoming involved there. So when I do go sit there, I see many people up. I sometimes lost count, up to 10 people per day, coming not only, as I mentioned, straight from motion court because they have a problem, but coming from magistrates' courts, or that they've received summonses or eviction notices, matrimonial problems, succession problems. And what I do is I look at what they have, I listen to the narrative that they tell, I decide or I recommend if it is, I often give advice as to what can be done immediately. If it is something that would entail litigation, which I cannot, I've undertaken some of those as roles myself, but I cannot mostly do that. And then I recommend to the pro bono organization that an attorney in that specific field be appointed to assist a certain person.
All right, thank you. I'm happy with that. We've given you bail appeals as well. Have you done a bail appeal?
I have done.
Can you tell us what is it that should be satisfied in order for an accused who is charged on Schedule 6?
Schedule 6
charge, yes. What is it that should be satisfied in terms of the Act for the court to grant bail?
I just want to make sure that I heard you right, Judge President. Schedule 6 offences.
Yes.
Are there exceptional circumstances which would, in the interest of justice, then would show that it would be in the interest of justice that the person be released on bail? So it differs from Section 5 offences where the accused would have to say or simply show it's in the interest of justice that he or she be released. The exceptional circumstances, and that onus is on the accused. That must be shown in Schedule 6.
Let me ask one last question. As you know that the qualities of a judge are not only confined to technical ability of a judge, but collegiality, temperament, and all of that. What contribution or value do you think you have, or a special trait that you'll be bringing to the court if you were to be appointed?
Judge President, I think there are a few aspects. What I think is important in a division is collegiality. That is because one deals with, and also an important aspect, diversity, but because one deals with strong people around one, one has to be able to get along with one's colleagues and be able to discuss issues, even if there are contentious issues, to have fierce debates, if necessary, about matters. So I think that I have the temperament. I get along with people. I am naturally, I suppose, a peacemaker, but I do stand my ground. I think further that the issue of language is, as far as the Western Cape is concerned, at least, an important thing. I am Afrikaans speaking, as you know. And in trials, especially, one often finds that there is an immense discord between what is translated between Afrikaans and English counsel jumps in and says, no, that's not what was said. And I find the same in relation to, if I think back to the criminal trial that I did, Xhosa and English. And that is why initially I think I've told you I've started learning Zulu, but I've in the meantime changed over to Xhosa. And one of the registrars is assisting me on that basis, on the understanding that I teach him Afrikaans, although his Afrikaans is much better than my very beginner Xhosa. And then it is, one must have a good work ethic, because one simply cannot pass matters on to already overburdened colleagues. That is not on. So if I get a matter, I try and see it through. If I have other matters, then I make arrangements to fit the work that I couldn't do on a specific day, to fit it in. I do not want to bother my colleagues with those with matters that
Okay, thank you. Thank you.
That I deal with.
Judge Panse.
Thank you,
All
Judge
right.
President.
Thank you,
Thanks,
Judge
JP. Advocate question.
Thank you, Chief Justice. Advocate. I wanted to say earlier, you've actually put me in a bit of a bind. I have to behave myself because my wife was also an Urania, so she'll chastise me if I'm rude to a fellow.
And I wouldn't accuse you of being biased, Commissioner.
Just a technical question from my side.
Yes.
Within the context of administrative law and procurement, I suppose more specifically, would unlawfulness and even intentional and dishonest unlawfulness automatically give rise to delictual liability? In other words, or even a breach of constitutional rights within that context, without more, found a delictual claim?
As the law, as I understand the law at the moment, and there has been much debate on that issue because people are understandably, developers, for example, are understandably dissatisfied with the way that decisions are taken by government organizations. For example, municipalities, take that example in rezoning applications. But one must be very careful not to, in a sense, bind those government organizations to such an extent that they are scared of fulfilling their obligations because of the risk of liability. I can offhand, I haven't looked at the matter recently, but can offhand think of a matter where there was such gross incompetence that a court, I think it was the Steenkamp matter, that the court felt that delictual liability could follow. But those cases are few and far between. I suspect that the more these things are discussed and come to the forefront, the more emphasis is being placed on proper service delivery and accountability, the easier it will become for courts to develop the law to get to the extent where one can hold a government institution, apart from one's remedies under the various, under review, hold them liable for damages incurred on a delictual basis.
But would one not, in terms of the principle of subsidiarity, not have to always defer to Section 8 of PAJA to remedy the compensatory aspect of unlawful administrative action?
Of course, and that I suppose is because the court has a fairly wide discretion under Section 8 of PAJA. And I suppose that has been one of the reasons why there hasn't been a flood of delictual actions, at least not successful ones, in the courts. Because a court dealing with a matter such as that under PAJA already has the opportunity of addressing those types of issues. That is quite correct.
Thank you, Chief Justice.
Commissioner Poso. Thank you, Chief Justice. Good afternoon, Ms. Advocate Franceo.
Good afternoon.
Yes. For how long did you say you were acting?
I started acting in 2022 for 3 terms, 2023 for 3 terms, all in all about 9.5 terms. So the term that I am currently acting, which started last week, will be the 10th and a half, if I could call it that. So about 10.5 terms at the end of June, because I'll be in court on Monday.
Okay. Are you aware of the anti-sexual harassment policy?
I am very much aware of that policy. I've printed a copy of it out and I have it in front of me. It is unfortunate that it is necessary even to go to these lengths, but it is necessary and it is long overdue. It is a well-written policy that not only the bench, but the bar and the legal fraternity as a whole should take cognizance of. I know that the Cape Bar has a policy along the same lines, but it is necessary and I support it wholeheartedly. I may, from personal experience, mention that early in my career I was called pussycat by a male colleague. Now that is a minor issue. At the time I tried to laugh it off, but it
is not minor.
The more I think about it, the more I think I should have been really mad and I should have showed it. But as I pointed out earlier, I was a woman young at the bar and I needed work. I vied for work. So I am intensely grateful that this policy is now here and it can be used and referred to.
Thank you very much.
Thank you.
Ms. Mansell. Thank you, CJ.
Thank you, Commissioner Poso. Minister?
Okay, thank you very much, CJ. Advocate Fansel, one thing that I got interested in, I'm not so sure if I missed it.
Yes.
And I must say, I must commend you for the transformative work that you do, especially the work that you are doing on the desk. I think it translates to direct meaning of access to justice. I think I must reflect that.
Thank you, Ms.
There's something again I picked up that I got interested in, where you are saying you prefer things to be amicably resolved because you understand how expensive litigation and its emotional toll it can take.
Yes.
Just your views in terms of, because with regards to certain courts, for example, Gauteng, intending to put mediation as part of the processes, but others advocating for that. And there are those who are waking or who are advocating against this, saying that it brings constitutional limits on the judicial powers and sets imminent erosion of litigation and the rights through unlawful judicial overreach. What's your view on that?
Yes, obviously, as a judge, one has to be very careful because one cannot, in a sense, one cannot go and tell parties to go and settle on a certain basis. So that is an aspect that must be very, very carefully handled. But in my work, certainly as an advocate, I've called a spade a spade. If I think that there is scope for the resolution of a dispute outside of litigation, I have followed that route. I think also that as a judge, even as a judge, we should encourage mediation. Even if judges are not actively part thereof, it should be encouraged because many disputes that clog the court rolls are disputes that can in fact be mediated by somebody who can assist the parties to communicate effectively, to narrow the issues. At least insofar as judges are concerned, we can motivate the parties to narrow issues in order to limit aspects of litigation that we may do. But as I said, it's a road that for a judge might be a treacherous one. One must be very careful. But I am wholeheartedly in support of mediation, and particularly in relation to certain aspects of work where clearly proper communication and the eradication of the emotions on both sides can lead to the inexpensive, in time in time and costs, resolution of disputes.
Thank you.
Thank you, Minister.
Thank you. No further questions, Commissioners? All right. That brings us to the end of your interview.
Thank you, Chief Justice.
Our last interview this session.
I am glad, and I hope that
I hope it's a good omen for you.
I hope that I enjoyed the interview, and I hope that you did too. I'm very grateful that you listened to me, and thank you for your work in this commission. I respect it immensely.
No, thank you very much, Advocate. You're excused.
Thank you.
Clear the room for deliberations, please.